for today is sharing in the experiences of established international arbitration seats. The session is being chaired by Mr. Abhinav Bhushan, Director, South Asia International Court of Arbitration. The speakers are Mr. Vivek Kapoor, Stephenson Harwood LLP London, Ms. Smriti Ramesh, Assistant Director, Kuala Lumpur Regional Arbitration Center, Mr. Pranav Maggu, Head, South Asia, Singapore International Arbitration Center, Mr. Tejas Karya, Partner, Head of Arbitration Practice in Shardul Amarchand Mangaldas. I request the Chairman to kindly commence the session.
Good morning. Taking forward the second leg of the arbitration conference today, Your Highness, Mr. Salman Khurshid, Mr. Moses, my esteemed panelists. It's quite interesting that the palette that we have today on the panel sort of truly represents the topic of the session, which is sharing in the experiences of established international arbitration seats. And I say that because on my far right is Vivek. Vivek has spent several years in Singapore, an established seat, and recently moved with Stephenson Harwood in London. On my immediate right is Mr. Karya, who is almost synonymous with international arbitration, heads the disputes and the international arbitration practice in Singapore, in Shardul Amarchand Mangaldas, and has had experience in various international arbitration. In fact, myself, when I was a deputy counsel in Paris, have had the pleasure of having Mr. Karya represent clients in several international arbitration disputes seated across the world. On my immediate left is Smriti. Smriti is not only a junior from Government Law College, Bombay, but is now number 2, in the words of her own boss, at the Kuala Lumpur Regional Arbitration Center. On the far left is Pranav Maggu, who spent a lot of time in Singapore and is now the South Asia head for SIAC and is based out of Bombay. Which also I think is worth mentioning that the 4 prominent institutions based in Asia, which is SIAC, is represented by an Indian, Pranav Maggu, KLRCA, which is represented by an Indian, Smriti. We're missing the HKIC, but even HKIC for the longest time had Aditya Kurian, who was in the upper echelons of the management in HKIC. And for what it's worth, I represent the ICC, an Indian from Singapore. So taking the cue from there, the topic today is the experiences in established international arbitration seats. And we have 4 experts here with us today. So how we've decided to go about it is that we will share our experiences and different anecdotes that we have experienced in these international arbitration seats. They could be guerrilla tactics, they could be the war stories, which actually is also worth mentioning. The term guerrilla tactics is often used in arbitrations today. And sometimes it is often confused with the word guerrilla. Which is not the case, because guerrilla is a Spanish word. It has its roots from Spain, and it's actually guerrilla, which a native Spanish speaker, Ms. Perez, just informed me about. So guerrilla tactics are those which parties resort to in an international arbitration, a recalcitrant party, often the case, to stall the proceedings or to delay the proceedings or to make the life of everybody else difficult in international arbitration. So without further ado, I would first request Vivek to share his experiences of an established international arbitration seat.
Thank you, Abhinav. So as Abhinav said, I recently relocated from Singapore to London, and before that I was, I was in the US and I've practiced in India. So a question I often get asked is, what is the difference between London as a seat and Singapore as a seat? Now, Singapore has really massively grown. It is an international seat. It has a very stable law. It has a judiciary that supports. One of the key differences I feel where London has an advantage, and I'm not trying to sell London as a seat because I'm based there, is the pool of talent. The pool of talent means the pool of talent of arbitrators, counsel, experts. Now, that is very important because of the simple reason that when commercial parties go to a seat to arbitrate, they need all these people. And it is very important to have local talent. And coming back to the discussion about India, which was very central yesterday, India needs to grow that pool of talent. That pool of talent in terms of arbitrators, who are not only judges, but also lawyers who have the expertise, who have the industry experience, lawyers, a very focused arbitration bar, and a pool of experts who can be used in various arbitrations. It is not cost effective for parties to fly in lawyers, arbitrators from London, Singapore, Hong Kong. And I think that is one of the key differences in my experience. Yeah, sorry.
Follow-up question. So how would you think, Vivek, can we develop a pool of talent in India? We do realize, and we have an audience today, and let's try and give this a twist of controversy, which is that senior advocates, and I'm very acutely aware of the fact that Mr. Khurshid is sitting in the audience, they don't want to do international arbitration because it cuts their court time. People who are distinguished practitioners of the country today don't want to do arbitration because it's frankly not their time. So how do we really build a bar in this country without the active support? Intentions, yes, but I don't know to what extent and how can we really develop a pool, a talent in it.
Well, I completely agree with you that I think there is a general feel good about arbitration. Everybody talks about promoting arbitration, but there is essential practical problems, like you very rightly pointed out. A senior practitioner like Mr. Khurshid would not be very keen to sit as an arbitrator, and I think that is what we need to change. We have a good pool of judges, but we need to look beyond that because of a whole host of reasons. You see disputes which are very industry specific, energy, infrastructure, construction. You need people who have that experience. You need to bring in talent from law firms. You need to ensure that even senior advocates, people like Tejas, need to also start sitting as arbitrators. I think there is that mindset that needs to change. And that mindset needs to change even when it comes to lawyers. Because an arbitration lawyer and a litigation lawyer, though they're both adversarial proceedings, need to have a different viewpoint, need to operate in a different manner. India's biggest problem has been that arbitrations have been done like litigation. It's, the post 4 o'clock, the post hearings. And that is a change in the mindset which needs to happen.
But isn't this a chicken and egg story? I see a lot of younger practitioners sitting here. I see Manisha sitting here, Anu sitting here. So what advice would you give to them that how can they establish themselves at the cost of not earning enough money and yet establishing themselves in international arbitration when, quite frankly, there isn't much work for a younger practitioner today to start with in the field of international arbitration? How do they really go about it? What would be your 2 cents worth of advice to them?
Well, I started practicing at the bar, and I can tell you that in law in India, there is no money to be made initially. So don't worry about the money. Keep the money aside for a second. What you need to do initially in law, as somebody at the bar, at a law firm, is develop your talent, develop your skill set. You get an opportunity to work on a case, do that. You get an opportunity to attend a conference, read. You need to sort of try to build that skill set. It is a chicken and egg story. You cannot build that skill set without getting the right opportunities. But you need to start.
Thank you. Tejas, would you like to add your expert comments?
Sure. Good morning, everybody. It's a pleasure to be here. Talking about established seat, there are so many things comes to mind when you are actually selecting a seat, because seat is a very important aspect in an arbitration. As we all know, everything depends on the seat because you select your court, you select your procedural law, And at the end of the day, infrastructure, which is very important, the talent, as Vivek said. So when Indians are selecting a seat, what would come to their mind? So their mind comes, first thing is the cost, which is where they will save the cost in terms of if the matter goes for an arbitration. And also they think about the friendliness of the local courts, because for interim relief or for execution of award or challenge of the award, exactly what needs to be seen is the court's role in the arbitration process. And invariably we have seen is that they also look for a strong institutional support, because if you don't have an institution in a particular seat, then they are not sure of selecting a seat. And if we take all these aspects into consideration, if you see, the answer is there why India is not a preferred seat for international commercial arbitration. Because if you see in comparison, we are comparing India with particular cities, London, Singapore, Kuala Lumpur. We are not talking about England. Singapore is a city-state, but we are not talking about Malaysia. We can never have India as a seat. We have to have a particular city developed as the seat. And what all we need for that is a proper infrastructure. And we cannot believe that country like India cannot have transcript services easily available. We have to get people from Singapore and Hong Kong to do transcript services. And sometimes clients refuse because they say, okay, fine, we will do with the screen and a laptop rather than transcript, because the comparative cost of getting transcript from other jurisdiction is prohibitive. Secondly, a proper hearing rooms. In India, we use places like this arbitration, which is not efficient. I was telling Smriti that I was in KLRCA a few months back, and the kind of infrastructure they have. You have Maxwell Chambers in Singapore, you have IDRC in London. Why can't we have the similar places in India? We have ICADR, but the way it is structured, it needs revamp. It's not the way the arbitration institutions work in other jurisdictions. So we have potential to be a preferred seat, but there are many things which we need to do. And fortunately for us, yesterday we had CJI and he was quite pro arbitration. Even the future Chief Justices have seen that, shown the proactiveness about the arbitration, and they are pro-arbitration. But they cannot take too much of interest into arbitration process. Arbitration has to be left on its own. It cannot be controlled by courts. The courts have only role, the courts have to do with support the arbitration process only in limited circumstances, as we all know. But unfortunately, after the amendment also, we have seen so many intervention by the court into interpretation of the amendment, starting from applicability of amendment to various aspects of the thing. So it's a never-ending process as far as court intervention is concerned. And given this geography of India and the other jurisdictions which we are comparing with, there is much more to learn from those jurisdictions and implement it here. And we have experts from all the jurisdictions who can tell us what all we need to learn from this jurisdiction to be effective and change the mindset. At the end of the day, we have the talent, we have the arbitration practitioners, and I would not suggest that we don't make money in arbitration. Even if you do full-time arbitration, you will make money. And it's not necessary that we have to target the same set of experienced lawyers who are successful in court to do arbitration, because even if you see any other jurisdiction, that's not the case. You have senior counsels who are expert in court proceedings. You have other arbitration practitioners who do full-time arbitration. So in India, we have thousands of lawyers passing out every year. It's so easy for them to specialize in a particular field, which is never going to die. Every commercial contract will have an arbitration clause, and every contract will somewhere parties are there and they may end up in dispute. So we are talking of something certain. So there is no problem with regard to selecting a field, which is, and you need a different skill set. It's not that in our firm also we have lawyers who do everything, but the efficiency is not the same if you do only a kind of work which requires to be done in arbitration practice. So those are the pros and cons, and I'm sure we'll discuss as we go along in the panel. Thank you.
You mentioned that we're not talking about Malaysia, we're talking about Kuala Lumpur, we're not talking about England, we're talking about London, and therefore India should have one seat. Yesterday we were talking about balancing national interest versus commercial interest when Olga gave that brilliant presentation on bilateral investment treaty. So now let's try and balance state interest versus national interest. So if we have to pick one seat in India, one city in India, I know you're from Ahmedabad, Pranav is I'm from Saharanpur, less relevant in the context of international arbitration. There are people from Bombay here. So what would that one seat for you would be in India to make that seat a particular hub of arbitration? I know you're born in Ahmedabad, but you work primarily out of Delhi. So what would that seat be for you in India?
No, so just to clarify, I never wanted to indicate that there should be only one seat in India. But when we talk of seat, it should be a specified city. It could be 5 or 6, depends on the party's choice. But whatever seat they select, they can only select that for international commercial arbitration if you meet all the 5 or 6 parameters. So I'm not suggesting, and it cannot be, it's not like a Supreme Court where you have only one place in India. But if you see of any other thing, now you have NCLT also in all the jurisdictions. You have many tribunals having separate seats across India. And high courts, of course, are there in every state. So I'm suggesting that you empower every place with all the requirements of a preferred seat rather than just talking about India. Because when we talk of India, we forget about the requirements for making a established seat. Today we are talking about established seat, and that requires a lot of things to be done rather than keeping it as an ad hoc seat and then trying to work around various aspects of preferred seat.
As a follow-up question, you've had arbitration seated in London, you've had English law as the applicable law of the contract. You come from a recognized, reputed law firm in India. So when you have London as the seat of arbitration, but the governing law of the contract is, say, India, does that change your consideration in having the support of a non-Indian law firm at the place of arbitration? Is that a consideration that you would have just because you want to be secure that there is a seat which is non-Indian and you may want to have the benefit of having the counsel of a foreign lawyer?
That really depends, because Indian law or English law doesn't, because in arbitration, the law, more of it's a procedure. So we look at the institutional rules, and substantive law, of course, plays a major role, but if it is a common law jurisdiction, then really doesn't matter who takes the lead in presenting in the arbitration. We always go on merits. If you need a counsel who is not well-versed with Indian law, but is very good in his skill set for arbitration, or to that matter, law firms. Like every law firm now has India desk, and they have expert Indian lawyers working in foreign law firms. So they are either qualified in India or they have the enough experience in India, like Vivek and others. We work very closely with foreign law firm as a co-counsel. And they do equally good, even though it's English law or Indian law, or sometimes we have done arbitration in ICC, which is governed by German law. So that doesn't matter so long as you know the rules, institutional rules, as well as the basic fundamental process for this thing. Because when you see parties coming from different jurisdictions, for example, in US it's more of a discovery intensive proceedings where they want everything to be discovered immediately when we work with US law firms. When we work with English law firms, they are more focused on presentations and doing good presentation before the tribunal. And a lot depends on tribunal composition also, because whether we like it or not, there is something called White Men's Club, and we need to kind of be sensitive about it rather than ignoring it. And we have to balance out the expectation, because the way Indians present the case before QCs or law lords there and the QC presenting before the QC, we have seen the difference. And we have recently done an arbitration where we could see the apparent difference in the approach of the tribunal when we have somebody from known face in front of them whom they meet otherwise regularly.
Thank you. Just out of curiosity, because of limited resources to make cities into centers which have arbitration facilities, hypothetically, if the government of India today decides to do that and say has $100 to do that and decides to start with one city, keeping your personal biases aside, could I ask by a show of hands from the audience, the two cities that come to my mind are Delhi and Bombay. Keeping in mind where business happens in India, which is the national capital, can I ask the audience, which city would the audience prefer that we first invest in making that city as the center of arbitration, and then, of course, later transgress into other cities? How many people would vote for Delhi? How many people would vote for Bombay?
In Delhi, you are asking about Bombay.
Keeping personal biases aside, are you from Bombay? Yes, you raised your hand for Bombay, right? Are you from Bombay? So why would you do Bombay versus, why would you prefer Bombay over Delhi in terms of arbitration practices? Okay, this may raise a lot of controversy, so we will move to Smriti immediately. So Smriti, you were born in Chennai, studied in Madras, went to Berkeley, from Berkeley to Kuala Lumpur. And now you represent a country which is one of the most developed countries in Asia, with a strong sort of a drive towards international arbitration. And I'm sure all of us would benefit from your experiences as an Indian in Kuala Lumpur, a developing country and a developing arbitration jurisdiction, a developed country and a developing arbitration jurisdiction.
Thank you, Abhinav. Good morning to everyone. Thank you for coming here on a Sunday. I think Abhinav just started off with the one thing that I wanted to open with. Malaysia and India have two things in common. One is me, and the other is that they are both jurisdictions that faced a lot of challenges, and they're both jurisdictions that played catch-up or continuing to play catch-up with other developed jurisdictions like London or Paris. And the way that I see it as a perspective is how Malaysia developed as a safe seat. And I think there are a few key points that I think are very applicable both to India. Would be how an institution played the role as facilitator. And when I say facilitator, I believe that it goes right down to something that Justice Sri Krishna brought about yesterday. That is, it's very imperative to change the fabric of the society to becoming a society that's more prone to alternative dispute resolution. And this we did by not just focusing directly on international arbitration, but by focusing on building a domestic fabric. Now, just to give you a heads up of how we did it, in 2010, and Malaysia had an arbitration act that wasn't amended for many years. In 1952, the first arbitration act was passed, and it stayed that way till 2005. In fact, India got there before Malaysia did as far as amending the act goes. But what happened is between the year 2010 to 2016, we were able to bring about a 96% increase in the use of not just institutional methods of dispute resolution, but also a drastic increase in domestic. And we did this by focusing on the niche needs of the industry. Yesterday, there was a lot of talk about construction being very prevalent as far as arbitration disputes go. And to do this, we did a lot of research to come up with a statutory adjudication mechanism, which is a summary system of disposal, but it did a lot to alleviate the cash flow problems. And this also did a lot to bring about trust in the domestic sector for the use of alternative dispute resolution. And apart from this, of course, it's very, very relevant to bring about a 360-degree level of capacity building in the form of the judiciary, the Bar Council, and your businesses and practitioners. Because when you are a developing jurisdiction, when you're trying to establish a safe seat, the one key issue that you face is credibility. Apart from logistical issues such as cost, I mean, we could have the best facilities, but if people didn't believe in the seat, if people didn't believe in the talent pool and the awareness created, then it becomes a huge setback. Now, the other thing that quickly addresses Abhinav's question is, what about the younger practitioners? Now, there's a term that I really like that Justice Sundaresh Menon, the Chief Justice of Singapore, used. He said, ADR no longer stands for alternative, it stands for appropriate dispute resolution. Now, there's a lot of avenues for younger practitioners, such as domain name dispute resolution. Yesterday, I was trying to speak to a couple of young practitioners who did not have any inclination of the availability of domain name dispute resolution and still went back to courts for trademark injunctions, whereas a domain name dispute resolution can be done completely online. There's a lot of room for young practitioners to become panelists or arbitrators in avenues like this, and the entire process takes 15 days as opposed to going to court and getting an injunction, so on and so forth. So if there is a focus, in my opinion, apart from all the all the other excellent suggestions that came out, it would be to target niche areas that are relevant to the country and what are the biggest issues that are plaguing India, and to develop solutions that not just promote international, but also domestic. And I think that would be the fastest way to making India a safe seat. Thank you.
Thanks, Priti. And I think that's a very important point, and we forget this sometimes. I said this in the October conference as well, that I did have the benefit of seeing the growth of developing and developed countries and their arbitration practices while I worked on close to about 1,000 arbitrations from start to finish in the last 4 years. Now, when we are in India, we have already started with a hope that we would become Singapore or London or Hong Kong or Paris very soon. I think sometimes we forget that countries where arbitration has prospered, it has taken about close to 100 years for arbitration to prosper when it started in Europe. Now, I wouldn't give the specific example of Singapore. Singapore is an exception to the rule because it's a country which has 6 million people as opposed to 1.3 billion people. The dynamics that are present in Singapore are very, very different to the dynamics that are present in India. I live in Singapore, and people who are present and do arbitrations here, they know that the government of Singapore has the ability to change their laws overnight. There are countries who start thinking of doing a legislative change. Singapore probably gets to know about it, or it was already in the process, and they just do. They call a cabinet meeting, and I don't know the exact procedure, but they just do it overnight. So I think we started, frankly, after the 1940 Act and the 1961 Act, the Awards Act, the Foreign Awards Act. It actually started in 1996. So frankly, India is a very young country when it comes to international arbitration. And to be able to sort of replicate the model or take the best practices from London, Singapore, and Hong Kong and insert them into India and then hope it would work, I don't think so it would work in that way. I think our practice would sort of, there'll be an organic growth. There needs to be an organic growth within itself by adopting the best practices, but they would sort of change themselves accordingly. The one thing that the practitioners do in developed jurisdictions like Paris, like London, like New York, or for that matter Geneva, is that there is a lot of engagement of arbitration practitioners amongst themselves. I can tell you, to organize a conference on international arbitration in India, the value that one gets in India to attend an international a conference of international arbitration is very different from what that value is perceived to be in a developed jurisdictions. There are various forums where practitioners actively engage in developed jurisdictions. For instance, there are institutions in those developed jurisdictions which provide that platform, whether that is by way of a young arbitrators forum or young SIAC or young LCIA, or whether those are trainings and conferences, or whether there are regular lectures and trainings in international arbitration. And there is a collective effort by the arbitral community in those developed jurisdictions to actively engage and promote the practice of international arbitration. I frankly think we don't have that in India. There are people who are making a lot of effort, but none of those efforts would succeed without the active contribution of the bar and the bench. And I think that is something that all of us sitting in the room should sort of reflect upon, whether you need to engage with the arbitral community to the best possible way and for the limited time that all of us have, whether we want to and how we want to spend it, if we want to build a career in international arbitration. Now, last and certainly not the least, Pranav. Pranav was in Singapore, has seen the growth of Singapore, and now represents probably one of the more dominant arbitral institutions in terms of statistics and numbers in Asia, that is the Singapore International Arbitration Center. In particular, I understand from the latest statistics of SIAC that the highest number of parties SIAC received were from India this year, and I'm sure Pranav can share with us the Singapore story and the India story, which is conjoined with the Singapore story. So Pranav, please share your views with us.
So thanks Abhinav, and thank you everyone for being here on a Sunday morning. The theme of this, I think, entire conference has been that, and probably from the last year when the amendments came out, that how we can promote India as a preferred seat, a preferred jurisdiction for international parties as well as domestic parties, and make it easier for everyone. So I thought I'll just put certain things in perspective regarding Singapore, which though a lot has been said, I do not completely agree with all the panelists here, and Abhinav just mentioned that Singapore is an exception. I believe Singapore is an exception with the exceptional growth it has had since the year 1991, or rather 1985, if you want to just take it 6 years back, when Singapore ratified become the signatory to the New York Convention. 6 years later, 1991, SIAC was set up, and at the same time, government set up a subcommittee to invite opinions as to how it can be more lucrative, it can be more incentivized, it can be a preferred jurisdiction, it can be a preferred seat. Since yesterday, we've heard a lot of suggestions. However, for every seat, there are quite a few important elements which are needed. And as they just pointed out, there are quite a few things which goes into when you choose a seat, goes behind choosing a seat. There's a lot of freedom which has been granted in Singapore to the parties, to the arbitrators, to the institutions. And there has been one pioneer factor which has driven this entire growth in Singapore since 1985, and that has actually been the government. The government has taken a lot of steps and is still continuing to take steps. Plenty of such examples. One such example, let's say, in the year 2010, when SIAC introduced expedited procedure and emergency arbitrator provisions, very soon Singapore went ahead and amended its International Arbitration Act, amended the definition of award, amended the definition of tribunal, to specifically include emergency arbitrator provisions, and so that it will be considered as an award and can be enforced that way. Similarly, the most recent example is third-party funding. So here is a government which is continuously trying to keep up with the best practices globally and is making efforts regarding that. 80% of the cases which SIAC received last year were international in nature. 50% had absolutely no connection to Singapore whatsoever, where it was and Singapore was a seat. So now this is something which can be used as an example in India, wherein how to promote this further. Now why this? There is a very pro-judicial approach. So the judiciary strongly supports arbitration, has been supporting it for a number of years now. There are two separate tracks of arbitration legislation. So there is a domestic track, there's an international track. Fundamental difference between the domestic track and the international track is the domestic track allows more court intervention, whereas the International Act completely puts a stop to it. We have something like that here in India. However, there have been gray lines and gray borders which have been crossed and created a lot of confusion in terms of precedence. Furthermore, going back, in 2004, Singapore amended its Advocates Act and allowed foreign practitioners to come in and set up shop, and especially international arbitration practices. So much so they incentivized the foreign practitioners to come in and set up international arbitration practice to the extent of 50% of tax exemption on it, something which is going to lapse on 30th June 2017, and it was for a period of 5 years. If India does something like that, I'm sure don't even need to give tax exemptions. Probably there are so many international firms wanting to come in, and the people who are going to get the choice of counsel, something which is very important in a seat. Till 2004, if it was a Singapore-seated arbitration, a foreign lawyer could come in and represent, but had to be accompanied by a Singaporean qualified lawyers as well. Amongst other things, and coming to another question Abhinav asked the audience, which is, and absolutely right as well, it's wrong to compare India to London to Singapore to Hong Kong, because we are talking about specific cities, sorry. Maharashtra recently came out with an arbitration policy, which is very, very encouraging, a great step on behalf of the government of Maharashtra, I think so it will go a long way in promoting institutional arbitration, wherein it says that all PSUs in Maharashtra over a certain threshold are supposed to have, mandatorily are supposed to have an institutional arbitration clause. However, there are further details in it which curbs certain party autonomy features which are extremely important in international arbitrations, any form of arbitrations for that matter. One of the cornerstones of arbitration is party autonomy. So while the government is making all these efforts and going leaps and bounds at it, it has to be done in a complete form. And whether if that requires some sort of suggestions from the other government, some sort of suggestion from the established seats, some sort of suggestion from institutional representatives, people are more than happy to help, I think so. And as Abhinav rightly started, SIAC, ICC, KLRCA and HKIC have all in the past and now are being represented by Indians. We are more than happy to come back and help our own country in terms of any suggestions which might need be. The amendments happened in 2015, October 2015, based on the 246 Law Commission report. I'm not going to say a lot about it because already a lot has been said. But again, we all know that what were the shortcomings, what were certain suggestions which were extremely important suggested in the Law Commission report, but not adopted here. MCI has come up with fantastic facilities, something which again, when we go back to the Singapore example, 2009 was when Maxwell Chambers had started. And it brought about a specific premises where parties could relate to that, okay, arbitrations is going to be happening at Maxwell Chambers. Parties still have the absolute choice of choosing any other venue as well, but there were these facilities. When I was in practice, it really opened my eyes. We were representing a Singaporean company against an Indian respondent. And the tribunal was constituted in Singapore, a 3-member tribunal. And there was a lot going on regarding schedule, there was a lot of scheduling conflicts, so we were not able to track down 10 days at a stretch for hearings. That is when the tribunal came up with the idea that our party is comfortable of doing it via video conference. And it worked very well. For 10 days continuously, we had hearings over video conference where the Indian respondent was represented by an Indian firm sitting here in India. They had fantastic facilities. Maxwell Chambers was more than happy to provide that, obviously at a cost. While they're more than happy to provide facilities, it comes at a cost. So, but it was quite easy. Things were made very, very, very simple. Still, I'm not too sure if there are any other facilities in India comparable to what MCI set up in last year, as to wherein they have the option of having such fantastic hearing facilities, such fantastic video conference facilities, wherein it saves a lot of time and cost. Now, these are the kind of things which go into the establishment of a preferred seat amongst. There has to be government support, there has to be pro-judicial approach, and there has to be such infrastructure also set up. So when we use the term, which has also been used quite a few times recently, the term ecosystem, the development of an entire ecosystem, it actually means a lot of aspects. But someone first needs to has to be the pioneer of it, which I believe has to be the government, like in the Singapore case. It has always been the government's approach, it has always been the government's effort there, which has been driving. Now this got me thinking that whether SIEC is responsible for Singapore becoming a preferred seat, or is Singapore's reputation as a preferred seat responsible for SIEC's caseload and growth of SIEC? I think so it's both. It goes hand in hand, completely goes hand in hand. While parties are absolutely free to choose any other preferred seat, whatever they have, and use SIEC rules, or for that matter, any other institutional rules as well, they made sure that while there is an institution which has a good reputation, it totally rides on the reputation of the country as well, and vice versa. So that way, Singapore has, I think so, done exceptionally well compared to other jurisdictions which are, rightly said, 100 years old, and the development has been going on for 100 years. This is something which was, I think so, compared, it's in infancy stage, 25 years old only. But at the same time, it's a perfect example. If an entire country cannot follow it, then definitely at least one of the cities, one of the states can start following it, as suggested. Thanks.
Thanks. And then there are other issues. For instance, question of visa. There are speakers who couldn't come for this conference because they couldn't get a visa. and this is an international arbitration conference. There are countries in the world who have a specific procedure for anything related to arbitration. The visa procedure is entirely different. Number one. Number two, my professor who taught me arbitration at Columbia Law School has been injuncted to come to India for the last 20 years because there's an anti-arbitration injunction which was given by a court. In his spirit to do arbitration, he proceeded to give the award. A contempt notice was issued, and that is one story. The perception outside of India amongst the foreign arbitrators is that they are not very comfortable to come to India for hearings because the question of fly in and fly out is not clear to their mind. Douglas Jones was here on the 23rd of October, and he spoke about it. And he mentioned how Australia has done it. Australia has published, the government of Australia has published on their website about the fly in, fly out policy. Now, there is a Madras High Court judgment which allows fly in, fly out policy. That judgment is sub judice in the Supreme Court right now. So the question is an unsettled area of law whether foreign arbitrators can come in, and fly out. Some do still, but the perception outside of India is that it is a generally a non-friendly place for international arbitration. Tax exemption, like Pranav mentioned, Singapore exempts tax on any income derived out of international arbitration for non-residents in Singapore. And there are various other things that India can do without much logistical hazard. But first we need to get the Bar Council of India, first we need to get the other stakeholders, the SILF, the government, the judiciary, and have the practice of just the allowance, the flexibility to have international arbitration in India. Pranav mentioned something about emergency arbitrator, and Tejas would perhaps be the best person to answer that question because I understand that you were a part of the committee. And as you know, that the Law Commission report mentioned the inclusion of the term emergency arbitrator also went on to the extent to define it. But when the amendments came out, the word emergency arbitrator was missing. And now today we don't know what would be the fate of an order rendered by an emergency arbitrator. Would that be read with Section 17 or not? Perhaps Tejas could tell us about that.
Yeah, so when part of the Law Commission suggestions, I was there and we deliberated a lot about whether emergency arbitrator is a tribunal. And the order passed under 17 is always passed by the tribunal. So if emergency arbitrator is not a tribunal, then the order is not recognized under 17. Because 17 we said that it has to be implemented as if it's an order passed by a court. So that's the logical sequence we followed, is that define the emergency arbitrator as the tribunal and then make it enforceable. Unfortunately, because there are not many arbitral institutions who offer emergency arbitrators facility in India, maybe the government thought it not to include it in the definition. But that doesn't stop the arbitral institutions like MCIAs now have emergency arbitration process. And the advantages of that is it takes up a lot of burden away from the court under Section 9. And that could be explored, and I'm sure the high-powered committee, Justice Sri Krishna was here yesterday, and one of the suggestions we have made is that to promote institutional arbitration and also emergency arbitrators, the powers should be the same as the tribunal, so that the order passed or the interim award or the award passed by emergency arbitrator granting interim measures is enforceable as if an order of the court.
Thanks. Vivek, and I'm also aware that Shai is sitting in the audience, with whom again I've had the privilege of working on some real case arbitrations when I was in Paris. And in the morning today with Mr. Khurshid, we were discussing about challenges to arbitrators. Now, in terms of developed jurisdictions and developing jurisdictions, for instance, India and others, as versus London as a developed jurisdiction, how do you perceive how do you take the perception of arbitrators? Would parties be inclined to challenge or question their independence at the same rate that we see in developing jurisdictions? For instance, the maximum challenges we receive at the ICC is from Latin America against arbitrators. In India, because of the relationship between the bar and bench, the equation is slightly different. But how would you compare that with the developed jurisdiction?
I think in India, if I start with India, people tend to take a very emotional view. I was doing this matter once, and my Indian client told me that let us, nominate so-and-so senior advocate. And then he told me some circumstances where there was a clear conflict of interest. So I told him that. He said, he's a senior advocate, he's a very eminent man, there is no conflict of interest, he can rise above that. And then, that is one side. And the other side is, they just, even a slight, not even a hint of bias, just a passing cloud, they want to challenge it. So in developing jurisdictions like India, it's very emotional. People want to, if blood is boiling, you just go in, ram it in. In a mature jurisdiction like London, Singapore, people tend to take a slightly more balanced view, slightly more mature view. And now you're talking about Latin America. Latin America, it's the same thing. Some of the Latin American work I've done, clients, take a very cowboyish view of things. Thanks.
Is there any question from the audience that we could take, and I could and address it to anybody on the panel? Is there anybody who'd like a question? Since we're going to end at probably at 11, so we have 5 minutes to do this. So any question to anybody, either related to this particular topic or otherwise? Yes.
Not being an apologist for anybody, but I have to correct Mr. Bhushan on matter of the visa. I dealt with it personally. There was a serious error in the application. 2 consul generals from one province in China and the other nearby tackled this issue at 6 p.m. their time, opened the consulate to correct this error, which was so serious that it had to be redone on Monday. So I think it was
No, thank you for that. No, I'm aware of it personally, but the point I think I was trying to make is that had there been a procedure which exists in other countries to get a visa for a matter related to arbitration, which other countries have and we don't, and perhaps we could benefit from having one, is the point that I was trying to make. It wasn't who made the wrong or the right application. Of course, there was an error on that part, but had there been a parallel process which is available in other countries, could have benefited this situation or many more that will arise in the future. Yes, Zafar. Sure. Sorry. After that.
So I think what came out today was that a lot of the stakeholders need to get involved in the process. It's not just the government alone is not going to be able to make the changes to make this seat a more habitable, more welcoming seat like some of the more established ones are. From the experience of working with these similar stakeholders in other arbitration seats, who do you think has to take the lead in India? Is there one side or one party that can really start driving the process? Because in Singapore, it may have been the government that really sort of pushed that process forward. But here we know that we love our brothers and our compatriots in all the associations in India, but they can be quite recalcitrant to change. And often that sort of stagnates the process of trying to adapt to changing circumstances, changing technologies, changing changing state of litigation, arbitration, any dispute resolution in the world. So how do you think that really will be addressed or can be addressed in India?
Who's that to?
I'm happy for anyone on the panel to take that.
Well, there's actually 2 possible answers to that question. And again, just to draw back to Malaysia, where it's fairly impossible to change legislation, unlike some jurisdictions. The easy answer, and I think the first change has to come from the Bar Council, where it should be a process of bringing together, because once the Bar Council is on board, and that's how it started in Malaysia, was to bring together the judiciary and the legislators and to bring about a 360-degree overview. But the way that it happened in Malaysia was that the Bar Council was unable to do it, and therefore they had to go through, they facilitated it through the institution, where it made for a more neutral form of lobbying, for the lack of a better word. But yeah, in my opinion, I think in India, the best suited start would be to get the Bar Council involved, and involved very aggressively.
Can I make a quick correction? And Smriti is completely right. The Bar Council in Malaysia, in India, it has to be the bar. Because I'll tell you, because I practiced here. Yeah. Bar Council, there's a lot of politics, there are a lot of players.
Understand.
Which is, Mr. Khurshid is smiling. And I think the bar generally needs to get behind it. Because a lot of the judiciary is also from the bar. Places like Malaysia, Singapore, there is a very homogenized system. Here, there are multiple stakeholders. There is the Bar Council of India, there are the different states. All of them are fairly politicized. The dynamic is very different. The bar needs to get behind it. The government, I think, is doing its bit. In this modern day, there is sort of a corporatization of governance. So everybody is very conscious of these things. The government takes note. They try to make all these changes.
Hi, good morning everyone. I'm Mohit from Kranjawal and Company. My question here emanates from the topic when Vivek was talking about developing a pool of arbitrators in India. As we all know that it's currently dominated by retired judges of Supreme Court, High Court and various other courts in India. Do you think that there would be a mind change of parties when it comes to appointment of arbitrators in India? Like non-retired judges and all, would parties, because when we do arbitration, we see that when a claimant appoints or nominates an arbitrator who is a retired judge, the other party is under pressure to have a retired judge as their nomination for the panel. So do you think that this mindset would ever change in India?
Just before anybody answers, I just want to say one thing in support, which is, I think there is a lot of unjustified bashing of retired judges in the country. There are some excellent retired judges who act as arbitrators, and then there are some who don't. I would say perhaps there are more who don't than who do. And because of them, the ones who do also sort of, one bad apple makes the entire basket bad kind of a story. I've had the privilege of having India's top retired judges act as arbitrators, and my pleasure has been nothing, my experience has been nothing but phenomenal. So whilst I think we need the counsel and the advice of the learned judges who are now retired, you're quite right that on the same hand, we need to develop a pool of young talent for arbitration. Now, how exactly? I mean, I've done my part of the speaking. Perhaps somebody else can address this part of the question.
Thanks. In fact, I have a counter question to it. Because why is the fact that, and I completely agree with Abhinav, that there's a lot of bashing, whether justified or unjustified, we'll leave that part out, but there's definitely a lot of bashing of the retired High Court and Supreme Court judges. But why is that? Why is it only nominating retired High Court and Supreme Court judges? Something which I think so flows from the previous question, which is that the bar needs to get behind it. When you talk about a change in mindset, if I understand correctly, a lot of times the nomination of arbitrators here happens depending on who the other side has nominated. For example, if it's a retired High Court judge, automatically the notion, and which is actually advised by the councils representing the parties. Clients don't go out themselves researching on arbitrators. And I'm quite sure of it, learning from experience of my colleagues and my friends here. It is just but natural that the other side would also want to appoint a retired High Court or a Supreme Court judge, or maybe a Supreme Court judge and someone who's more senior. Why? Why is that needed? Absolutely, it's not needed at all. In fact, Singapore is one such example, and I can only speak about that confidently, being my experience there, wherein I had the privilege and the experience of working with arbitral tribunals, acting as a secretary to the tribunal, because the partner whom I was working with was acting as an arbitrator, having been nominated by another firm. Now, how many such instances do we have here in India? Vivek just mentioned that he would want to see people like Tejas. We would also want to see people like Tejas and other practitioners acting as arbitrators. That's how the pool of arbitrators is going to develop. Once there is enough, I would say enough trust and the confidence of nominating your colleague or your contemporary as an arbitrator. The knowledge will develop there. Amongst other things, and obviously there has to be a formal training. There has to be an accrediting institution. There has to be someone who gives out the formal training of writing an award, which is very similar but still slightly different from writing a judgment. So such kind of training facility, such kind of pool needs to be developed, and I believe that's how it's going to be.
Yes, and all those who want to see Tejas as acting as an arbitrator can see him now, because he just recently got appointed as an arbitrator in an ICC matter, which goes to show that going forward, I can speak on behalf of the ICC. We recently came out with our expedited set of rules for any dispute less than $2 million, which roughly translates to 12 crores, would go to a sole arbitrator, considered as a low-value dispute. The award will come within 6 months, preferably if the sole arbitrator so decides, without a hearing, on paper only, submissions on paper only. And even if the arbitration clause says that the tribunal will consist of 3 members, by default, because the contract was entered into after 1st of March 2017, because that's when the rules started to apply, even if the contract says 3 arbitrators, because they have also contracted into the expedited rules, the court will appoint a sole arbitrator, and the fee structure of that mechanism is less than what the fee structure for disputes where amount in dispute is more than $2 million. And the ICC court and the president, Alexei, has indicated that the ICC will endeavor to appoint as much as possible the younger generation of arbitrators for procedures that will go towards the expedited procedures. And I understand that would cater to the audience that is present here. And in this regard, I would encourage all of you to engage with me, likewise with other institutions who have similar procedures, with the ICC India offices. We have a new Tejas Chauhan, who's a new ICC India coordinator, and engage with him, give him your resume, tell them that you're interested, and that's how we will start this journey to make an arbitration bar. I understand Vivek wanted to make a quick comment.
Yes, and I completely agree with Abhinav, what he said. And the point Smriti had made earlier, something like domain name disputes, we need to understand that, and I'll steer clear of judge bashing, that you look at a Supreme Court retired judge or a very senior practitioner when you're looking at a massive dispute, a dam, or an oil rig. However, in a country like India, which is growing tremendously, there are a lot of disputes which are not of such magnitude. However, you need an arbitrator, you need a counsel, and that is where there are a lot of opportunities for the younger generation. So when it is a smaller dispute, where you don't need that kind of expertise, you can bring in your peers, nominate somebody who's senior to you as an arbitrator. You can do your own advocacy. You can, you don't need to get the whole paraphernalia which you need for a very big arbitration, because the majority still are small and medium-sized claims which can be done in a very organized manner by the younger generation of the bar and the law firms, I mean.
So yes, just adding to that, Abhinav is absolutely right. Institutions need to play a role, and a very major role at that, in developing a pool of arbitrators. However, there is a fear in terms of appointing younger arbitrators, which is very much prevalent in India. I will definitely not name, but a very, very senior judge once said last year at a public gathering, so it was not in a private conversation, that whenever an arbitral award is challenged and it comes in front of him, the first thing he looks at is who the arbitrator was. Now, to be very frank, that's got absolutely no relation with it. If anything, the name of the arbitrator should be redacted. Why do you really need to know who the arbitrator was? That is a fear which Indian parties have. That is a fear that comes back to the appointment which I just mentioned, that there will be a retired High Court judge, there has to be someone senior, someone who's known, someone well known in the market, is someone with integrity, and these were literally the words used at that point in time. And it was indeed quite surprising that, and clearly that's why the pool of arbitrators remains limited. Now, if Mr. XYZ, who would have a lot of knowledge and a lot of enthusiasm as well as a lot of experience in arbitration, but Judge XYZ doesn't know Mr. XYZ, so it might just be a ground for setting aside. A judge might just scrutinize the award way more and look for something in it which maybe there, maybe not be there, which, and again it was said out loud, that which would probably be ignored if the judge knows that the person is someone of integrity, which we know what it translates to.
Just last thing that I wanted to add, that I think at the base of all of that, whether it's appointing young people or not, is the prevalence of ad hoc arbitrations and the lack of popularity of institutional appointments, irrespective of whether it's a domestic institution or an international institution. Where, and I would like to point the example of China, which stands in stark contrast to India, where most of the arbitrations are completely institutional in China, where most of the arbitrations are completely ad hoc in India. When you have an institution appointing, governing costs, governing procedure, you will see that there's an increase, like Abhinav pointed out, there are many institutions that have a policy to look at appointing younger arbitrators. To add to this pool, I must add that when something comes to me, I make it a point to at least see if there is a female arbitrator. This is something that we leave out of the equation very often when we talk about it. Not just is the age a matter, but there also needs to be gender equality and bridging the gender disparity. So once you promote a fabric of institutional arbitration, you will see that these things start to change slowly, but definitely.
On gender equality, there's a pledge in the international arbitration community now to appoint as much as possible women in arbitration. Most institutions, statistically, if you see last year, for instance, ICC appoint 10%, roughly 10%, or more than 10% of the appointments that were made by the ICC court last year were women. Internally, when we today look at appointing somebody, there is always a proposal of a woman out there to make this practice of arbitration as diverse and gender neutral as possible. There's an institution, organization, Arbitral Women, that exists, and one of the purposes of Arbitral Women is to support and promote the practice by women in international arbitration. So it is not completely a white boy dominated society. I think things are changing in the right direction, and I encourage all here to actively engage with that. Just one last quick point. We also have a tendency to nominate our arbitrators because we want our arbitrators to bat for ourselves. I have a very interesting quick anecdote. I was working as a counsel. There was an Indian party. The Indian party nominated a retired High Court judge, and we sent the forms of independence and impartiality for that arbitrator to send it back to us so that we can then forward it to the parties. Now, this arbitrator did not come back to us within the stipulated time. I called him. He did not respond. I called him again. Now, the procedure was being stalled, and it was the job of the institution to make sure when it comes to these administrative questions, the matter is run smoothly. So finally, I got hold of his wife. I said, ma'am, I need to speak to sir. Sir got online. I said, Abhinav, I was about to fill the forms. Sorry for the slight delay, but I have just one question I want to ask you. I see in the form there's a question about disclosure and whether I am independent vis-a-vis the party or not. I think I am completely independent vis-a-vis the party. But I just had one lingering question I wanted to ask you. You see, my office is rented to me by the claimant. And I am not sure if I should disclose this or not, because I am otherwise very independent. So I said, sir, thank you, one, for mentioning this to me. Now, even if you don't disclose it in the form, the fact that you've mentioned this to me, I think that the court is unlikely to confirm you in the arbitration. But that's very unfair. I said, sir, I can't talk much about it now, but I think you should mention this, and the court, and we will circulate these forms to the other side, and let's see what comes out of it. And that is a problem. It is a problem so grave that the judge decided to ignore it and think that he was completely independent of situation. There was a direct financial relationship between the party and the arbitrator. In another case, of course, I was injuncted to come back to India because a leading law firm of the country decided to file an anti-arbitration injunction and saw an Indian name working at the ICC. So normally these injunctions come in the name of the President or the Secretary General, but that was a day of honor for me when the injunction came to the Paris in my name by the Delhi High Court back in the days. And there was an anti-arbitration injunction. We were not allowed to proceed with arbitration. In that case, the ICC represented itself in the Delhi High Court. And finally, the injunction was vacated, but I was not allowed to come back to India, just the way I'm not allowed to go to Pakistan and Nigeria because of injunctions. So these things happen, you know, and you wouldn't find these war stories from developed jurisdictions. And these are the things we need to take care of. But I think Vivek has a last comment. But that's about, yes, there's a question. And that will be the last question, and then I think we'll end the panel.
The panel quickly shoot out what are the best practices for a young arbitrator as well as the arbitral institutions.
Sorry?
Could you kindly quickly shoot out the best practices for an young arbitrator or an arbitral institution so that the young arbitrators will be benefited?
That's a one-day conference,
Yeah.
but Tejas will take that.
Quickly shoot out.
Yes.
Yeah, so for young arbitrators, the main thing is the availability and training, because you need to be recognized to be available and trained to conduct arbitration, because you need to realize one thing, that for parties it's like a life and death, because you are going to be a judge, and for normally to decide who your judge should be, you need to have a trust, you need to know about the competency and integrity. So all these things can be instilled in the party's mind only if you have done enough work. So experience is very important for young arbitrators. You must work as much as possible in different spheres of arbitration, and training and accreditation. Like you have courses offered by Chartered Institute of Arbitrators. That is something you can consider to do. There are various levels. There is an associate, member and fellowship courses that is recognized by all the arbitration institutions. Similarly, you should, for arbitral institutions also, there are many things which they can do is training courses, promote younger arbitrators for, as Abhinav said, in smaller disputes, and that builds the profile of an arbitrator, because the more cases you do, you are likely to get more work. So that is how it's a quick summary of what all you should do.
On that note, thank you so much for being a patient audience, and I must thank and congratulate my panelists for sharing their views at the conference today. Thank you.
आपका है ना लैपटॉप? हाँ यहाँ पर।
इसका सर लाइट सर इसका इस पर डार्क Put him high out of my gada.
Your Highness, you're here.
Here?
That's right. Stay there. Okay. Oh, the position of your camera, okay.
It's according to...
Yeah, the cameras, fine.
Huh?
Proper semicircle so you can see everybody.
Okay, yeah.
No, it should be on this side. Show me this side because she'll be talking to him.
Yeah?
It should be this side.
Like that?
Yeah.
Disturb? Like it? No, it's okay. Not big. So we need to tuck it inside. And do you have a pocket inside? Pocket? No. You can tuck it somewhere with this skirt or something. Okay, right, okay. Do you want me to help? Here? Like that?
Okay. Oh. Yes, we'll just what we'll do is.
Like that? Now?
Yeah. And what we'll tuck it, just tuck it in.
Now it's okay. Okay.
Under the belt. and we'll just count the time.
It's
Okay.
okay, like that? Or we
Just
bring
make
it
it
up?
more neat.
5,
Sure.
huh? Okay.
Weird. Weird. We don't get sticky time today. The mic. Moses.
This okay?
Sorry.
Can I try the
Hi,
sound?
I put it on air. I put it
Can
on
I
air.
try the sound?
You can say it.
It's already on.
Yeah, it's already on.
Hello? Hello?
You comfortable?
Yeah, I can't hear my own voice though.
No, no, no. You can't hear the voice.
Oh, okay. That's the
only
point.
we can hear the voice. Yeah.
All right,
Okay.
fine.
Great. Thank you.
Nice to meet you. Rohini.
Hello, 1, 2, 3, 4. 1, 2, 3, 4.
1, 2, 3, 4. 1, 2, 3, 4.
1, 2, 3, 4.
That's loud. 1, 2, 3, 4.
1, 2, 3, 4.
So audio is all in order?
Yep.
So we'll just wait for the MC to just give an announcement for the audience here.
Yeah.
And then so you can take over from there. Yeah.
Okay, terrific. Where will the MC speak from?
Thank you.
You've taken her podium away from the side.
Excuse me. Sorry, sir. I think your bio is something about touch. Can you, if you don't mind, just something more? Or do you want to keep talking?
One more button.
Or maybe I can try and switch the wire and something like that.
This is major adjustment, really. Thank you.
In India, we can.
Yes.
So we're starting with the next session, and the theme is India and the Future of International Commercial Arbitration. And the session is televised. It will be broadcasted next week on NDTV Profit, and the details will be available on the website. So the moderator for the session is Senior Advocate Mr. Salman Khurshid, former Minister for Law and Justice and External Affairs, and I request Sir to kindly commence the session.
Thank you very much, and good morning to everyone. Good morning on a bright Sunday morning. We've had good discussions thus far, and this in many ways will encapsulate some of the discussions that have already taken place. I'm delighted to introduce this remarkable panel. On my right, we are honored to have Her Highness Sheikh Haya Rashid Al Khalifa, who's the principal and founding partner of Haya Rashid Al Khalifa Law Firm in Manama, Bahrain. On Her Highness's right is Mr. Sudhir Sharma, who's partner in Luthra and Luthra Law Offices, New Delhi. And then equally weighty on the left, my friend Mr. Ajay Behel, co-founder and managing partner of AZB and Partners. And then finally on the left flank, Ms. Rohini Roy, who is the Chief of Legal Operations, Bharat Heavy Electricals Limited. So you can look forward to some interesting interactions. If I may, Your Highness, begin with you. Set the ball rolling.
Thank you very much. I think India and the future of the international arbitration, I think for any jurisdiction, in order to be an arbitration hub, we have to build an arbitration culture. It is important to fix or to prepare the mindset of the people, either the lawyers and the legal community, or the commerciant, the people who use the arbitration. We have to build this culture. What does this mean? It means that we build the trust on the method of arbitration as a dispute resolution. We have to build the trust. Does India has the potential? Yes, of course. In spite of what we heard today morning, I think India has the potential. India has adopted the modern international legal system, legal method, and become now a signatory of New York Convention for the enforcement of the arbitral award. Further, India adopted the unilateral model law as one of and become one of its jurisdiction, become part of its legal system. So, and from my part of the world, we saw India in many very big legal firms, international legal firms, Indian young lawyers, and also in general Indian has also the talents. We said this morning that we need to build to have a pool of talents in India. We have it. You have it. Okay. And for one reason, India can become, or it's a international arbitration hub, because the great history of India in international commerce, and secondly, the geographic location of India between the East and the West, between both different legal systems, and the civil law system, which is in our area in the Gulf and in the Asian part of the Arab countries, we are all adopted the civil law system, and between Singapore, Hong Kong, and I think all the countries who adopt the common law system. So from my part, from my opinion, I think India can be easily a hub for the international arbitration.
Well, thank you very much. It's certainly encouraging. I'm sure that everybody in the audience is delighted to hear this from you, coming from a place that is there's a huge nucleus of banking, and therefore we can all look forward to much greater cooperation, collaboration between our two friendly countries, Bahrain and India. But you've obviously spoken on a much larger expanse, and we will see how we get further reactions to this. May I now come to you, my friend Ajay Bahel, and let's hear from you what your experiences and your perceptions are.
So, Salman, as you know, I'm an optimist. I always said I'm an optimist, and I'm delighted to hear what Her Highness has said. But I'm also a realist. And I think we've got to look at this issue under two separate buckets. One is insofar as the immediate term, which is India's response to the recognition that international commercial arbitration and awards passed under international commercial arbitration should be respected. And that is one separate issue. And I think to that the courts have been responding very favorably, and I'm sure we'll get a chance to discuss that in greater detail. The second, which I think is the more tricky one, and where we have to be more realistic than optimistic, is when can we make India a destination for hosting international commercial arbitrations? And as you know, yesterday I did, from my experience, share what I think it takes to make a country a hub or a center. It requires a lot of things to be done. And I think we've made some strides, but I do believe that we have a long way to go before we can get people comfortable to arbitrate internationally in India. And it's very simple. You raised a very fundamental point. Do we have an arbitration culture? And it's I put it in a very simple way. If I find it difficult, or if I am not happy getting into a made-in-India car, I can't expect the rest of the world to take a car exported from India. And I think we've got to get ready to first believe that, do we believe in arbitration as a suitable, cost-effective remedy in India for ourselves before we can tell the international community to come here?
Okay, it's a good combination of realism and optimism, and we'll see how, as this discussion goes forward, whether realism prevails over optimism or it's the other way around. If I might come to you, Mr. Sudhir Sharma, because from what has already been stated, I think the lay of the land looks favorable, but there may still be surprises. So let's see what you have to say.
So I would like to lean towards the side of optimism. I think the intent was always there to take requisite steps. Now they are being followed up by requisite action, and the latest amendment which is carried out to Arbitration Conciliation Act is one of the most important act in the right direction, and requisite changes have been made in the framework of Arbitration Conciliation Act as far as the legislation is concerned to facilitate international arbitration. And one of the biggest roadblock, as Mr. Bahel pointed out, was the enforcement of international award, arbitration award. And by making the requisite changes in a concept like public policy, which was considered to be one of the biggest roadblock, and narrowing down its scope, it has been abundantly demonstrated that we are serious about enforcement, things like enforcement of the award and the proper conduct of the arbitration in India. Now, what is lacking, according to me, is at the moment is the infrastructure. Probably we need to have a very good infrastructure and the suitable framework of rules for institution rules which are comparable to the best in the world in order to make it more effective. Infrastructure, when I talk about things like transcription and translations, are still not available in this country. And whereas we are looking at the time frame to complete the arbitration, 18 months. But if we don't have these requisite facilities, so I know as a practitioner of the arbitration, you face a huge problem in completing and finishing the arbitration in time. So unless and until we have those kind of facilities and that kind of infrastructure, I don't think we will be able to attain the full potential that the international arbitration regime is capable of achieving in this country.
I'd like to come back to this point a little bit later as to the specifics of infrastructure, because everyone here is familiar with what is offered in different parts of the world. And we'll come back to this a little bit later, but let's continue with the general drift of this broad picture that we are trying to put together. So if I may ask you, Rohini, to give your points of view. You made some interesting observations yesterday, but let's see where we go.
That, of course, was a different ambit altogether. But I think that when it comes to the scenario of international commercial arbitration, yes, of course, optimism is the order of the day. But I think that there are problems which we need to sort out. And perhaps it would suffice to state that the opening position of, which would be the summary of my stand, would be that it needs to be understood and appreciated that destructive litigation is really not the cornerstone of arbitration. And it is important because somehow this has become the default position in times to come today. And I think we're essentially looking at a colossal change in the attitude with which arbitration is practiced as a medium. A lot of the success story, I think, would depend on how we accept this change. And I always say that a criminal is basically a person with predatory instincts who has not got sufficient capital to form a corporation. So we have started giving different interpretations, and because there are so many varied interpretations of looking at the same stand, it is important to accept that sometimes it is necessary to destroy a village before actually setting it up afresh. So this openness to transition is perhaps the cornerstone of arbitrations today in India. But of course, there is hope.
Thank you. Thanks. That's again, as I said, interesting observations. Your Highness, would you want to take this discussion further? Or?
Yeah. Yes, I think regarding what Mr. Sharma said regarding the public order, maybe sometimes cause a public policy. We call it public order in Bahrain. Public policy. There is an expression in the international arbitration which is international public policy. So the international arbitrators sometimes they use this kind of expression in order to make the principle apply widely. So we have to introduce such kind of concepts to our legal community inside India or inside our area, because this will keep the arbitration more flexible and more entering with the international concepts which they use it in the international arbitration. I give you example from Bahrain practice in applying certain texts. We have in Bahrain in our law of procedure text which said the following, that in the enforcement, related to the enforcement, Bahrain can enforce the international award in conditions. The first condition is that Bahrain is not competent to resolve this dispute. Bahrain is not competent. Now, if Bahrain is competent, that we cannot enforce this judgment. And maybe before 20 years, there was a judgment from Kuwait. They want to enforce it in Bahrain. And Bahrain and Kuwait at that time were competent to resolve this dispute, both Bahrain. And it was disputed between the two parties, and there was a judgment. I was a part of in this case. So we submitted a judgment from Egypt, which took the following principle: that if Bahrain law said that it's not possible to enforce a judgment if Bahrain court is competent, he doesn't mean that only Bahrain is not competent. He means that if there is both jurisdiction for both country, that means multiple jurisdiction of Bahrain and the other country, we can enforce the judgment. If there is a multiple jurisdiction, it's just like interpretation very developed of the judge of the courts. So we apply it, and the court take of it and enforce the judgment. What I mean of this, that it's better to make the mindset of the judges or the legal community understand, flexible and open to the enforcement, because the enforcement, according to the convention, if you enforce the judgment, that means you go a step further. That means you help or you encourage that this country can be has a arbitration friendly atmosphere. That's what I.
So you're actually suggesting that the mind should not be, or the attitude should not be parochial. It should be more wider and open, and that if there is a possibility that this would be enforced in the other country, then there is a sense that it should be enforced here as well, although on its own that might not have been the case, which is taking a larger and a wider view of public policy rather than a restricted and a narrow view of public policy. Would you like to say something on it?
Yes, I think what I understand is that there is a requirement to have play in the joints without any doubt. The judge before whom the matter is brought must have to play in the joints to decide as to whether this is an award which should be set aside or refuse the enforcement of the award. But in the context, as rightly said, that here we have two views. One is expressed by Rohini, which is a destructive litigation. So anything which could give rise to a ground of challenge any violation of substantive provision of Indian law was considered to be violative of public policy. So which is not the correct view. So I fully agree that the judge should have the play in the joint, yet we will do no harm to the growth of international arbitration if we, for the time being, provide a narrow definition of public policy and something which is capable of being interpreted by a court in a rather straight manner than a roundabout manner. So
it seems to me what you're saying is that there is a spectrum between being more, can't find a better word, but to say more nationalistic approach as against a more internationalist approach. Is that what you're getting at?
Okay. What I mean to say is that earlier the term public policy was not defined.
Right.
So the legislation came out with the definition of public policy. Now it lays down certain grounds, and again where the scope of discretion or interpretation is the term fundamental policy of Indian law. So that term in itself is capable of being construed and defined by the court. So as far as possible, the ground needs to be narrow and clearly stated, so as not to leave too much of scope of discretion. Yet at the same time, in fit cases, the courts have enough discretion to look into the matter and see that a proper justice is done between the parties without entering into the merits of the case. So anything which is like apparent on the face of it can be set aside by the court.
Thank you. You can always fall back on equity and good conscience.
That's right.
So
and notion of morality and justice also.
That's right. So do you have any response to this?
I'll just quickly second what's been said, but also I think one of the emerging perspectives now is on the appellate procedure. I'm not so sure that in today's globalization and economies where arbitration is really not about animosity anymore. It's not supposed to be an acrimonious battle between two corporates. We are actually looking to preserve relationships and not really destroy them. And very often when I arbitrate in the international forum, I find that there is an unusual, sort of uncommensurate level of animosity. Somewhere down the line, I feel that the corporates are actually looking at minimizing discussions which can go on to appeal. And somewhere down the line, we're actually looking to finish a process. So this whole appellate authority system, I understand that for fair trial and for natural justice, it's important that we have a recourse. But I think when you speak of public policy, if the definition is too wide, as he rightly said, it invites problems because the finality of the dispute becomes questionable. And then the integrity of what we're actually promoting suddenly seems lost because there are resources, there is cost, there is time, and then all over again, even though we say it's only on points of law and not factual, we end up opening the facts at some point or the other indirectly. So I think there is a need to sort of curb the amount of leverage in appeal.
I think I think there are three parts. First, I think we're still talking about the bucket purely of enforcement of international awards.
Yes.
We haven't got into India as a destination, so I don't want to mix the two things in terms of the optimism. So yes, there's great optimism because the courts, so to what Sudhir said, the courts have clearly said you can't reopen the facts, number one. Number two, the revised definition of public policy would suggest that every infraction of Indian law doesn't mean an infraction of public policy, which I think was the settled view at that point as well. I think where the problem is, and I think it's, it's always great to be very open and debate this issue, but I think you're going to run into some fundamental problems here when you deal with laws like FEMA, when you deal with concepts of damages, exemplary damages, punitive damages. That's where this rubber is going to hit the road. And I would have really preferred if legislature steps in and said that, listen, for avoidance of doubt, these areas are the fundamental policy of Indian law. Because you are going to run into a situation where two companies adopt a foreign law, which let's say permits punitive damages. Now when that comes to India, and that could be destructive of an entire corporation, the way we've seen overseas, and you don't have insurance, you don't have that kind of tortious claims, where are we going to end up with something like that? We've already had a court which has said FEMA is no longer the fundamental policy of law. Part of our fundamental public policy. I'm not so sure. I mean, of course, the question is, you see, it's changed from criminal to civil, but the suggestion in some quarters is that FEMA today is permissive in that you can condone anything you do by paying a penalty. That's not correct. I cannot today become an investor in a prohibited business like defense and retail and say, oh, by the way, I'll pay a fine, and I should therefore be condoned in my behavior. The FEMA doesn't say that. FEMA will stop you from conducting that practice. So what I'm saying is, it's very good that we've narrowed it down. Clearly, facts should not be reopened. Not every infraction of an Indian statute should be a breach of fundamental policy of Indian law. But what the fundamental policy of Indian law, I would respectfully submit, is better defined, initially at least by legislature, rather than letting it develop over many years because the uncertainty will remain.
Yeah. I think that's an important point. And there's perhaps a sense, as far as the legislature is concerned, that if you narrow it down too much, then you may have a difficulty in future that you've not anticipated. So leave it open. But that again is Ajay is saying that will take a long time for courts then to redefine and confine, and that may be a critical moment lost for driving people towards India as a destination. But
may I just add one point here? Sure. I mean, a lot of the decisions we are seeing go to one very fundamental tenet: bad facts make bad law. And we have people who have tried to approbate and reprobate, and the courts have said that's not possible. You can't go and tell a foreign investor that what I have done requires no approvals, and now you've come to India and you say, oh, by the way, everything I did was wrong, it was illegal, and therefore you can't enforce. So you can see the angst in the judgment, and rightly so, that you cannot just go and use Indian law as a tool to get out of a problem, which I completely agree with. But I think in all of that, we should not lose in that angst the fundamental issue that we have bigger issues to deal with. And sometimes people who are international investors, including our clients, we let them know that these are difficult areas. You cannot overcome, for example, the valuation guideline. You should be ready to accept that you cannot get a fixed return just if the company is gone bust, as an example.
Yeah.
Now today we are also confused because the courts are going so dramatically in favor of international commercial awards that even we don't know what exactly the position any longer is. It's becoming actually uncertain.
Rudy, could I just ask you that while we are looking at the spectrum of international arbitration and India being a destination, just to take Ajay's example, that if you're asking someone to come and try out a car made in India, then you're going to be comfortable in that car yourself to begin with, and that you would have high esteem. That car should be in your high esteem. Now, dealing with public sector, which has a whole lot of arbitration issues, which are domestic. I'm not talking about necessarily international arbitrations. That's where the platform begins. What is it that we could take back and say things are happening here which will address larger issues as far as international arbitration is concerned?
I think very, very appropriately put. I think the cornerstone of the whole situation, the success of arbitration going forward in the years to come, is essentially it boils down to investor confidence. And as you rightly said, if you do not have faith in what you produce and what you do, it is very difficult to convince another person of that faith. And it is important because when you're talking of public sector acquisitions, these are widespread operations. There is a lot of acquirement that happens. But sadly, I think one area where we need to still instill confidence is the delivery and the qualitative aspect of that delivery. And that is so important when it comes back to instilling faith in the system. It's all interconnected. Of course, I think that contracting is also a major part of the struggle. I always speak to my peers on contracting because I think proactive management of contracts can essentially ensure and take care of a lot of the loopholes. But I think you cannot predict so many situations arising out of a contract, and that's where the problem really starts. So when you have multi-layered clauses, which are actually designed in a way where even before you approach arbitration, there is mediation, there is an informal dispute resolution. By the time you actually exercise this option, a significant amount of resources and faith in the system is already lost and it's time gone. So while the process of arbitration may be 3 or 4 years, you're actually looking at an immense amount of time which has lapsed before and an immense amount of time which is going to lapse further. And so it becomes a never-ending struggle. But going forward, I don't know whether this multi-layered system could really help us. Maybe it is important to finish things and move on with, because our business is not really to arbitrate. The main business, the core expertise, is to be in business.
Well, since our Arbitration Act has conciliation in it as well, although for commercial matters, to what extent is the element of conciliation, mediation useful, or is it just an illusory thing that happens to be there, it looks good, but it doesn't really serve any purpose?
I think it's, again, a very important point because it's a question of the mindset that you have. And fortunately or unfortunately, the PSU mindset is still evolving. And we actually sometimes consider this to be a process which needs to be gone with blindly, irrespective of the results that it yields. So the idea, the attitude is, if a court of law says that I have to pay, so be it. That's not going to be contributory to my guilt conscience of not having performed because it's been ratified by a court.
Or the CBI asking you questions.
PCs are always relevant.
Exactly. So eventually you get into this circuit, which is like a vicious circle. You don't allow the mediation to succeed the way it should. And you're not, the conciliation is actually a failure because you're not trying to participate to make it work. You have the cushion of arbitration and a larger cushion of appeal, and maybe an even larger cushion someday of reopening everything on a different point of law. So it is fairly complicated, and I think that's where the change really lies, that we need to look forward to change.
Your Highness, do you have any views on this? That the issue of mediation, conciliation, even in commercial matters, before you actually reach the arbitration level?
Before also you have to build the culture. You have to make people understand what is the mediation. Normally, when we tell our client there is a solution of mediation, we can mediate, there will be a final judgment, I can enforce it? This is the first question. So this shouldn't be like that. A mediation is an discussion amicable, and you will find amicable settlement between both of you, and each one take his the result and enforce it and execute it himself, not the court. So I think also in this respect, I don't know in India, but in our area, they are always asked, there will be a final and enforceable word? And
which is the problem there. Yeah. Sudhir, may I just come to you now? Let's move on to the specifics in terms of infrastructure and the wish list that people would have if they look seriously at India as a destination.
Yes, I think it starts with the basic infrastructure like hearing centers. We don't normally, when we have to choose a place, to conduct the arbitration, we have the choices like India Habitat Center, India International Center, which are not equipped to conduct the arbitration proceeding. So first of all, we should have a proper building which houses the hearing centers in a proper way, and which has all the facility like internet and conference facilities, audio and video. And then again, when we talk about infrastructure, we should things like transcription and translation, which are being adopted worldwide to such a good effective use. Those facilities are completely missing as far as the India is concerned. So I think those are the areas to be focused on straight away without any further discussion. And then as we go along, then further areas can be identified and catered to. But for the timing, these are the two main.
But are some of those add-ons actually provided by private firms who obviously would be asked by the center to provide them? Are those in any way not available in India? I mean, could it not just be?
They are available. It's not that they are not available, but as I said, things like transcription. Like in two of our arbitration, the need was felt very desperately. But those agencies are not here. They are operating outside India. And I think if we are looking at concluding an arbitration in 18 months' time, and in my experience, sometimes the cross-examination becomes a rather lengthy process because the question is asked and then the answer is given, and sometimes it is deleted and modified, and it consumes a lot of time. So if you are looking at the time frame of 18 months, we must have these facilities. So other facilities can still be provided, like a proper screen, computer, internet. All those things are available, but things like transcription and translation, which are very important, are still not available.
So if I just come to you, the issue of having an attractive destination in India would, for a while, it seems from the discussion that we've heard yesterday, for a while would need to ride piggyback on rules of various institutions that are available today in the world. And therefore, the whole question yesterday of are we to reinvent the wheel? Will India require a separate set of outstanding rules that are especially in a sense reflective of Indian concerns and so on, and whether they would match the best that are available in the world? Do you have any views on this?
I think you need to have rules. In fact, we had the Niti Aayog of the conference recently, and there was a declaration after that. And I think three areas broadly, and Sudhir, I'm glad you wanted to the micro, but there are macro issues. And I want to go to the point that Her Highness made, which is in the beginning, the mindset. Are we ready for it? And I'll give you the ingredients that I think are necessary. So one, you need a soft touch law, which we don't have, which was identified, whether it's Section 11 in terms of the appointment of the arbitrator, whether it's in terms of the no provision of immunity, no provision specifically in the Act of Confidentiality. So those are some of the issues that the law needs to provide for and make it very soft touch in terms of the interference with the process, Section 9, how the courts have to respond. And that's a mindset issue. The law will always provide for interim relief. It's a mindset in the mind of the court. But one of the other things that was identified, which we hate to admit for ourselves, we don't have an arbitration bar. And if you expect people to come from overseas to arbitrate here, where is the arbitration bar? Where are the arbitrators? The arbitration bar is the lawyers who are available only when they don't have or when they've finished their court matters. I don't mean to look in your direction, but I'll look that side instead of looking at you. But that's great to be, that's the advantage or disadvantage of being a fantastic, busy lawyer. But so that's the first issue. The arbitrations are generally run by people who have been judicial in judiciary, and they run it as an extension of the court. And in fact, one of the tragedies here is that I started my career as an accountant, and when we had this conference, I said to the then Chief Justice and the others, and they were very responsive, that why don't we bring in more other professions into this particular process, like chartered accountants, because a lot of the arbitrations are all about damages, computation of claims, etc. They can support the process. And I was very disappointed that when I approached the institute as an erstwhile member, there was complete disinterest. I mean, their attitude, we already know it, and they are busy doing broker arbitrations on the stock exchange. So our mindset is, that what can we contribute? And if you look at the LCI website, Mr. Amal Ganguly, who's ex-Pricewaterhouse, he's probably the only arbitrator from India who's not a chartered or not a lawyer. But even something like getting a multidisciplinary panel of arbitrators is a channel. A bar is a challenge. So I think the infrastructure, the rules are necessary, the law has to change, but we have to recognize we have to do something very fundamentally different within the profession. Before we can tell the world, please come and arbitrate here. We can't find the lawyers to arbitrate for ourselves when we're doing a domestic arbitration. How do I tell a foreign client, please come to India, we'll make it happen, and you'll suddenly find a wonderful experience. So
that's interesting, but I think the problem frankly is not just about not having an arbitration bar. The question, I think the problem really is about the way our entire bar is structured. I mean, you look at lawyers in all the top countries of the world, and they take a case and they stick to that case for a week. Here, you take 200 cases, and then you're jumping from one to the other, and not probably
Absolutely. And written submissions, we've even submitted to the judiciary that why don't you insist on written submissions and give people limited amount of time. We litigated in America. I did a full trial, and which finished in 14 months. We had 42 pre-trial witnesses, 14 live witnesses. We met the judge's clerk only once. We were told, don't come back to the court, you will not be seen as being helpful to the court. And this involved discovery in Connecticut, it involved discovery in Singapore, in India, and went for a full trial, a jury trial. And we had a decision in 14 months. And the fact is the court was not responsible. The lawyers were responsible for delivering through the entire process. And that kind of responsibility has to be pushed by the judiciary on the bar and by the bar on the judiciary.
Absolutely.
Otherwise, change is not going to happen.
Tell me, has the context of the commercial courts made any difference at all? Or is it just a label that's been stuck on existing courts?
I think they have made a difference.
Yeah.
The approach is different, and it's, they understand the commercial trying to understand the commercial aspect and why these issues are required to be resolved or decision made on rather an urgent basis, and they can't be, hanging fire for a long period of time. But, coming back to the point made by Mr. Bhel, I fully agree with the point that he's made, but I would also like to say that, ever since these amendments have been introduced, I see a change in the landscape. I see that arbitration hearing happening from 11 o'clock instead of starting after 4:30 on a working day. So we are having full day arbitration, and we are having continuous arbitration for 3 days, 4 days. In most of our arbitration, the inclination in the first place is to finish and conclude the arbitration 12 months time period. Rather even not looking at the fallback of 6 months period which is provided under the Act. So I think the legislature has made correct noises and the correct changes, and in order to fructify, I think it will take time. But I think I've already started witnessing the change which is happening, the paradigm shift.
But I don't mean to sound pessimistic about it, but what the tragedy is, we needed a legislative intervention to make people do what they could have done otherwise, which goes back to the point Her Highness is raising, is the culture there. You bring in a deadline in the law, and if you were at the Niti Aayog conference, you could not imagine how much criticism there was of this timeline. And Mr. Jaitley was there and he said that, all we've said is if you exceed the timeline, go to the court. But there was total criticism from it was embarrassing that people, and they were expecting industrialists to say, we agree this is a too short a timeline. And most of the industrialists who were on the panel said, at the end of the day, we do lots of decisions, we do deals, we finish them in 18 months is a hell of a long time. So we would prefer to see arbitrations finish earlier than later. But everything doesn't require a legislative amendment. That's all my point is. And therefore, it's good to see the change. We are also seeing it, but is it in our core still, or is it just because it's being imposed by somebody? That's where I think the change needs to happen.
Also, I think that it was coming back to the point of Commercial Courts Act, that although it is the right noise, as he correctly put, but I'm yet to see the efficacy and the effectiveness of that legislation really at play, because the idea, the intention of having this act was to really create a dedicated expertise to this field, not only in terms of time management, so that it would help them to be dedicated, but also because we are essentially an economy where we are marrying technique with law. It is not possible anymore to just have a strictly legal bracket of interpretation. Viewing a case which concerns commercial aspects and technical aspects of the transaction cannot actually afford not to understand how a rotor not malfunctions, and that becomes sometimes more intricate than the interpretation of the statute itself. There's a lot of loopholing which happens. So yes, we have a commercial setup to dedicatedly handle it, but that practice is not being able to be effective because they're not able to marry this expertise together, and the true intent of the legislation is really to have a dedicated commercial expertise.
I think what seems to have happened is that this is an ad hoc arrangement that existing courts have been given the additional label of being commercial courts, whereas what we really needed to do is to have a dedicated division that was only commercial judges. Which is known. I mean, same thing happens in the Chancery Division in the UK. So there are people who are just on a different stream, and therefore they're equipped in a different manner, etc. But maybe that will come in times to come. Unless you have any other specific point to make, we could ask the audience to give us some questions to field. Shall we? So we have a little time. We have about 12 minutes. And I noticed that in the past sessions, we've not always had time to get all your questions in. So it's all yours now. Just identify yourself, please, and then ask for specific panelists to answer your question.
My name is Nandini Gore. I'm a senior partner in Karanjawala and Company. And I'm also in the validity section, so I was just putting that some questions are actually troubling me. What Mr. Behel rightly said, that arbitration, according to me, is a part-time job in our country. After the judiciary, the judges retire, they are taken as arbitrators, and immediately, in fact, we also, so-and-so judge has retired, I will take him as an arbitrator. Now the mindset, which Madam Highness said correctly, 100%, that the mindset when they are judges is of hearing the matter, the hearing goes on. So we are not disciplined at all. And what Mr. Behel said rightly, 100%, that we are not ready. We are at a premature stage right now to invite international arbitration in our country. So what should we do? What immediate steps we should take? That is my concern, and which always bothers me.
Well, I'll let the panelists respond to you, but one thing that you could do is not retire the judges.
I will not, never.
Then you won't have a problem of retired judges. Just let them be like the United States and the UK. Let them be judges till 75, and some of them are in good shape. Let them be judges and use their experience in courts, and therefore the tribunals will develop, the bar, the arbitration bar will develop, and there would be dedicated arbitrators. Anyone else wants to respond to that?
I think a lot of it is also to do with the shift from ad hoc to institutional arbitration. I think ad hoc arbitrations have outlived their spectrum of lifelines, and we need to move to institutional arbitration because it has a codified structure, at least there is some semblance of rules and some amount of discipline. I think the procedure that we adopt is another area of concern to really respond to what you're saying, because very often we are following procedures that are very long, are very hazy, because even the application of the Civil Procedure Code is actually, it's a matter of interpretation. Some arbitrators use it, some don't. Evidence, even if you're not following the Civil Procedure Code, sometimes evidence is done as per the CPC, whereas actually in a civil evidence, you do not need to have 420 questions. I have experienced that. There are 420 questions per witness, and it's going on as if it's a criminal trial, and the witness feels as if his fundamental rights are taken away. I think a lot of that streamlining will take effect if we move towards institutional arbitration.
Yeah, sure.
I think it's a very relevant observation. It's and while I take your point about the rules, those are all very important. I think it's also important to expand the availability of the arbitral pool. Today, people who are very well experienced from good firms, accounting firms, they'll call up and say, you know, they retire very early, as you know, 60, 62, a person retires. And I think one of the declarations that was made was that we need to start creating some training facilities where this vast pool of people who can contribute to the arbitration pool or the arbitrator pool, accountants, engineers. I mean, how beneficial would it be to have an engineer on a matter which involves a complicated issue of machines involved, pipelines involved, you talked about it. And there is an assumption, I remember at the same conference, it was when we were having the debates, I was mentioning accountants because very gently, and I said, we did learn a little law, because I know the first thing was, whenever you said, what do they know about law? I said, well, considering we did law, evening college, Kunjis, I don't know how much we know about law. I did do some law in the accounting profession. So it's not so difficult to train an engineer on basics of natural justice. And then what have you got the other lawyers in the panel for? Everybody has a role to play. So I think there's an enormous amount of talent pool in India, which is available from people who are retiring from senior positions in the government, very talented, people who are retiring from companies, people who are retiring from accounting firms, engineering organizations. I mean, BHEL, I'm sure if you had an engineer on an engineering dispute, it would help.
Hopefully.
If he's trained. But it's never been tried, till we tried, we won't know. So I think that is important, whether we have rules or we don't have rules. The number of arbitrators, and then the mindset will change. If you've got somebody who's not been in courts, he will treat the lawyers differently. He will want the processes to be much more what he's used to in running a corporation or running an organization, and he'll expect people to play ball with that. So I think all of that has to fall into place. It can't be one issue, but all of this has to come together.
And we have to start being comfortable with non-legal people in these arbitrations, because that has very little to do with litigation.
We have to believe people other than lawyers know law. I know when I switched from the accounting profession, I wasn't so way off from having some knowledge of law.
Become humble enough.
It was okay.
Okay, any further questions? Yeah?
Hi, this is Srishti. Arbitration has been considered as a form of alternative dispute resolution. But in recent years, what I have noticed as a young litigator is that increased intervention from the court somewhere has mitigated the concept of arbitration being an alternative dispute resolution scheme. So how do we ensure that the court's intervention is minimized and the independence of the tribunal is intact, doesn't get disturbed?
I thought that's beginning to happen, no?
Yes, I think it started happening already. And the judges, I think the lower judiciary especially, there's a move by DT Ayog in the last conference that we talk about, that there's a move to sensitize the judges about the least possible intervention which should be made. As I said, that legislative changes have already been introduced and the correct changes have been made which minimize the scope of intervention by the court. There is some level of preparation and this thing is required at the level of, as I said, the lower judiciary. At the high court level and Supreme Court level, I think it's already started happening, and some of the landmark judgments are reflective of the changing mindset of the judges. And I think the changes are already happening, it's just a matter of time.
But I think it's also to do with the fact that the the user community of this group, for example, the commercial enterprises, the corporates, it is also a mindset change of how much you want to use the courts. Well, no court will interfere with the process unless you give it the license to interfere. I think as a community of people who are using this, we need to get conscious and to advise our people as litigators that we will not approach the court given a choice, because after all, it is a dispute which you want to resolve. But I've seen many times the defendant wants to actually just waste time, and to buy time, they approach the court under miscellaneous little provisions. So this thing that we call ignorance, the vows of ignorance, are not binding on enrichment. And we need to understand that enlightenment comes at a very, very high cost. Enlightenment starts with us. So it's also about how we practice the profession.
And also one more point, I think there should be a regime of imposing suitable costs to deter frivolous litigation.
I wish you hadn't said that.
So I think, but if you see the 31A section which has been introduced, again it makes the right kind of changes, in the regime of costs which can be directed to be paid by the arbitrator or the court.
Thank you.
Yeah, we'll come to you.
Hi, my name is Anthony. I'm an advocate. So my question is an extension of what Ms. Roy and Mr. Bahl just said. So there is a reluctance on the side of parties and counsel to go for non-legal arbitrators, as you just said. So how do you think we can correct that reluctance? Can institutions play a role in that by training non-legal personnel to become arbitrators? Your comments on that, please.
I think first there has to be a willingness on our side, and maybe I'm an exception because I drifted into this profession accidentally, so I'm quite of the firm belief it's not rocket science. In fact, that's one of the fundamental things we use in AZB is not rocket science. Pape, Punjabi has to come into it. So I think, but training is helpful. I think that was one of the declarations that there should be some training colleges or facilities or institutions where you can train on the fundamentals, natural justice, principles of evidence. It's not, I don't think it's so difficult to persuade people to be able to join if they understand that this truly means, some added value for them. But I think training, interaction and making them feel that, it's not all about us, and accepting that others can also know the law has got to be the starting point where we have to give, and then you'll get some take back.
And of course, there are challenges because when you're doing this, when you're undertaking this training, you would have to effectively train a non-lawyer how to write an award. Now, I think that is rocket science sometimes, but it could be overcome if we believe and change the mindset of how we accept change. I mean, I think that the devil could change. He was once, after all, an angel, so he may be evolving still, who knows. But it's how you interpret change and how much you can accept it. It has to be on all levels, not just the organization, the people, the non-lawyers, and the lawyer community in accepting someone like that.
And may I add to that point, I think also in the arbitrator community, because to your point, Rohini, if the arbitrators are comfortable that the lawyers write the award, and the engineers and the accountants write their bit, even I do believe accountants can do a pretty good job at writing awards, but that apart, even if you allow them, that again, it's a question of the mindset of the arbitrators, that why can't we take this in pieces? You do what's best for purposes of the award, I do what is best, and we write it together. So again, all mindset. And you may not have the need for the engineer to write the award. He may just write, or he or she may just put in the pieces that are relevant for making the award more robust.
And the same change applies to the arbitrator community, even if you have a judge who's actually adjudicating as somebody who's used to litigation. They need to understand that now it's a hybrid technology. An award can no longer be just legal. It has to have technical aspects, and the technical aspects need to be read, understood. And for example, in France, when we had an experience of litigation, in arbitration, it was very nice to know that there is actually a judicial expert proceeding which takes place on the sidelines, so that the arbitrator, who is actually a judge of the court and whose domain expertise is legal, actually understands what technique is. And you have people from all over the world, specialists coming in to explain just the technical aspects. So there is a hearing dedicated to technique.
So you're suggesting that India is a good destination for the devil to evolve.
Devil to evolve. Right.
Hi, I'm Pranav Magu. I'm from SIAC. A lot has been said since yesterday about mindset, that we need a change in mindset for India to be a preferred destination for arbitration. And Mr. Bell rightly pointed out that so many times we've needed a legislative change to do something which we should have already done. I would just like to invite thoughts that do you think we need further legislative changes to ensure that best practices are adopted? Like for example, it was discussed yesterday that arbitration hearings so many times there's a request either from the council that the arbitration hearing should happen post 5 o'clock time, whereas it should be a practice like in court, it should be an entire day and continuously. Now these were some of the recommendations given by the Law Commission, not put in the report, but there was a recommendation that arbitration trial should happen on a day-to-day basis, something which internationally happens as a normal practice. Do you think we need more such legislative changes and put it into the statute itself that this is how the process should be followed?
We will remind the legal community when they protest about this change that you're the one who suggested it. We better not have any intention of practicing in India, because there'll be some angst at what you're saying. I mean, personally,
I think the important role is to build the trust on arbitration. Build the trust. This is your community, legal community, either lawyers or judges. You know, the problem when the arbitration towards the commercial community is the challenge. When you get after this 4 or 5 years arbitration time, then you have to go again to the court and challenge it. It's a very big problem. This is, if you build the trust on the arbitration and the arbitration award, then it will be very smooth, like in all over the world. It's not only in India, also in our area. As soon as you receive the arbitral award, you go and challenge it. It is really very bad. This is, and other thing, you have to just try to make people trust the arbitration award and accept it and go and enforce it. And
I know that the system is not perfect, but sometimes the system's imperfections is what makes it perfect for someone else to use. So I'm wondering at this point if we can actually use this adversity to our advantage and start evolving a process which takes care of both the aspects together. So I think the higher the change, the more glorious it is. So eventually we're looking at some point, and legislation is always a constantly evolving mechanism. And it needs to keep evolving, because when it stops, it really stagnates. And that's where, when change is not likely, that's not healthy. So it needs to improve all the time.
and as Sudhir has said, the time limit has changed things quite a bit. And I think having to legislate that you won't take adjournments would be reflecting poorly on the profession and on the others who are involved with the arbitration processes. And I think that would be a bit much. But the point that you make is all got to, at the end of be ingrained, and self-discipline is what is really going to make all this happen.
It could end up like this. Yeah. It could end up like the Sessions Court trials. CRPC saying from day to day.
Yes, exactly.
You know what I mean? Anyway, I think it's ultimately the attitude. Yeah. So with Her Highness's advise and appeal, if I may say that we can end this session on the note of advise and appeal. Thank you to all the panelists. I think you've done a great job. And thank you to the audience for listening in so carefully. And we can now move on to the final validatory session.
And thank you for being such a fantastic moderator.
Thank you. how are you? Welcome. I see that you're going to be taking your sister, Dr. Survey. She's done a great job. Thank you. Please sit. Please sit. Please sit.
This is former foreign minister, Mr. Salman Khurshid. Please sit. Please sit.
I request everyone to kindly be seated. We're getting right into the next session. I request the speakers for the valedictory session to kindly approach the stage.
Wonderful, wonderful. And I imagine that you're now on, you're now going to be on a.
Thank you. Thank you. Thank you very much. Thank you very much. I hope that we can do something.
Yes, yes, we will.
And we will keep in touch. I will write to George and we'll have this.
Inshallah.
Yeah, but we can do a collaboration. Thank you, George.
Good, have fun. Please enjoy.
That was very interesting.
Hi, Hi, how are you? It's your session now.
You're up now as well?
Yeah.
Oh, hi.
Hi,
I'm Nicholas. Nice to meet you.
Bye-bye.
Very bright.
Yes, of course.
Old,
China.
So that I get in there first. Nice try.
I request all the speakers to take the stage, please.
Sorry? We're just waiting for Kunal. Ah, there you are.
Just wait. Did you explain it to him?
There's no topic.
So,
She's done that.
So I'll just give some general remarks and then I'll let you start. Do you want to do that?
So basically, here we'll be summing up whatever we've gathered in the past 2 days. So we have an esteemed panel. The speakers are Mr. Shai Wade, partner Stevenson Howard LLP London, Dr. Nicholas, managing partner CMS Hong Kong, Ms. Nandini Gore, partner Karanjawala and Company Advocates, Mr. Kunal Vajani, partner Wadia Gandhi and Company, and Mr. Abhimanyu Bhandari, co-founding partner, Axon Partners LLP. So I'll request the speakers to kindly commence the session.
Thank you very much. We haven't discussed this before, but since I'm sitting in the middle, I'll just start and pretend I'm the moderator. First of all, I'd like to thank all of you who are still here on this Sunday noon. I think it has been a very interesting 2 days. Where we all learned a lot from each other. I can say that coming originally from Germany and now being based in Hong Kong for many years, but every time in India it's a learning experience for me, and these past 2 days have been, for me personally, very, very exciting, and I learned a lot. Let me just briefly set the tone for this last session of our summit, Engaging Asia. I think the topic says a lot, but in my view, Asia is already very much engaged in arbitration. If you look at what Asia has in terms of arbitration business, substantial arbitration business and substantial arbitration seats, it's really significant. Look at Hong Kong, 20 years ago, not really on the map of international arbitration, now the third most important seat in the world. 3 major institutions, the ICC, the HKIC, and CTAC, have offices and secretariats in Hong Kong, and the ICC secretariat there quickly, after it opened, I think 2008, became its busiest one. So that says a lot of how arbitration has engaged in Asia. Look at Singapore, the 4th most important and most chosen seat, according to the Queen Mary survey. With SIAC and ICC being present there, ICC will soon open another secretariat there, so it's a thriving seat. Look at Kuala Lumpur, a rising star, with the KLRCA doing a great job developing arbitration there. So I think arbitration in Asia has really arrived, and it is really already very much engaged. And again, I am originally from Germany, looking at the continental European perspective. 20 years ago, no European company would have thought of arbitrating in Asia. Today, it is completely different. There is a major shift east. In fact, that is the reason why I am here in Asia. Our firm has realized many years ago most of the arbitrations the large German companies are now involved in are no longer happening necessarily somewhere in Europe, but they're now happening more and more in Asia, simply because the Asian parties gain negotiation power and they gain a more important role and are able to shift the arbitrations east. So that is a process that has already happened, I believe Asia as a whole is therefore definitely already very much engaged. The second question, of course, is being here in Delhi, is how will India get its very much deserved role in this arbitration business in Asia? And there's a couple of points I'd like to make there. The Chief Justice said it yesterday: trust is the basis of every arbitration system and every arbitration proceeding. And I think trust is being built right now with the reforms that are happening, with the discussions we've just heard. I think India is on the best way to build more trust in the international business community to arbitrate in India. It's a key ingredient, and it of course takes time to build up trust to make international parties arbitrate their disputes in a certain country. Again, look at Hong Kong and Singapore. It didn't happen in one day that international companies suddenly agree to arbitrate there. For many years, I received calls from my partners in Europe asking me, look, I have this contract, there's an arbitration clause providing for Singapore, providing for Hong Kong. Can we do that? Is that safe? I don't get these calls anymore because everybody knows. But it takes time, and it will take time for India, but I think the road has been paved, and it's an excellent road as such. The second point I'd like to make, of course, are the logistics. That point was also made yesterday. I've attended many conferences at different arbitral locations where the same question was raised: how can this specific venue become an international arbitration hub? I think it was 2 years ago or 3 years ago that I attended such a conference in Sydney, in Australia, where there is perfect infrastructure in terms of airport, in terms of arbitration center, etc., but it's simply too far away. That's Sydney's problem. You don't get there. And if you get there, you need 2 days to recover from the journey. So that is, of course, a problem, for instance, Sydney has. India doesn't have this problem. Logistically, India is in the middle of everything. It's in the middle of the booming economies of Asia. So that box certainly can be ticked. One issue that, for instance, we have seen in Germany as a problem of becoming an arbitral hub is that there is no proper arbitration center in Germany, for instance. Singapore has Maxwell Chambers, Hong Kong has the HKIC. This is where people go to arbitrate. That's easy, and you don't even think about it. Germany has a problem. It has Frankfurt, it has Munich, it has Berlin, it has Hamburg. There's no arbitration center. So I think India, if there is to be one arbitration center in India, there needs to be one dedicated one, and it needs to be state-of-the-art, and it needs to be as good as Maxwell Chambers, as the KRCA in Kuala Lumpur, or as the HKIC. So I think that is a second requirement, but that is, of course, one that is easy to overcome. Those are the positive aspects. I need to make one critical remark, though. Again, I can refer you to my experience from Germany. The problem India will have in becoming a major arbitration hub is that its own economy is too strong. It's a growing economy, and it will have a lot of large arbitrations by large Indian companies. But these arbitrations will not be held in India. Same problem as China has. Chinese companies would love to arbitrate in China, but their international business partners will not agree to arbitration in China. So that is, of course, the problem India will face. And I was handed an article this morning talking about the German economy and how strong it is, and that it's doing really well. At the same time, I can tell you that arbitration in Germany is not doing very well. The caseload is declining, and more arbitrations are happening elsewhere, and it makes perfect sense against the background I just described. So that's just a thought, and it was also raised yesterday, that India, I think, cannot expect to get the big-ticket international arbitrations involving Indian companies simply because it's a logical exclusion that you will have a hard time pushing for India as a seat as an Indian company in a major contract. So that said, apart from those arbitrations, I think India is perfectly placed to become one major center in the region, like the KRSA is doing right now. Maybe not like Singapore and Hong Kong, simply for the reason that they don't have this problem. There is no industry, there is no exporting industry from Singapore and Hong Kong. They have the benefit of being able to be the neutral seat. So that said, these were my thoughts on the last 2 days, and I'd like to hand over to Shai to give us this, or would anybody else like to start? Okay.
Learned Senior Counsel Mr. Salman Khurshid, Mr. Moses, and distinguished colleagues from the bar and other colleagues who are here from all over the world. First of all, I want to congratulate Mr. Moses. This is my second or third experience with him, and he is occasionally doing every year. In fact, last year we were in China, and he is arranging these conferences which are actually very, very beneficial and which shows us the real mirror that what is going on all over the world as well as in our country. Yesterday, Chief Justice said that we have a big new building for our arbitration center.
So I'm not criticizing anything, but what I feel that a building with, all the facilities, the air conditions and everything is fine, but we need to have with the infrastructure other things also. That is what was discussed in the previous sections, that we need to have, the Arbitration, Conciliation and Mediation Act in India is there, under which in mediation they have a 40 hours compulsory training. I am a certified mediator from Supreme Court and I'm their panel also. So we did a training program for 40 hours which was mandatory to become an arbitrator. Like if you want to do a mediations in the Supreme Court or anywhere, you have to do that training which is necessary. So what I strongly believe that for arbitration also, rightly said in the previous session, that we should have some training programs for the arbitrators also, so that they have a mindset that, now of course the new act is there which is giving a mandatory requirement to clear or finish arbitration within a stipulated time. But still I feel that training is required, because we are famous for our court cases which keeps on going for 10 years, 15 years or 12 years or 20 years. For example, this Ram Janam Bhoomi matter came up before the court after 15 years. And when the Chief Justice said that why don't you people mediate, there was a lot of fuss on that. So, and another thing which is in my mind after hearing all the speakers is, in many countries I have seen, and I have traveled a lot and I have seen that pre-litigation mediation is compulsory in many countries, which is not so in our country. We can also think about arbitration also like that, that in the lower court or in the initial stage only, we can give a format to our clients and ask them that before going to the court, why don't you try mediation first or arbitration? And there is another concept which I just wrote down, that is called MEDARB. So you start with arbitration and you end up the matter with mediation. So what they do is in UK I attended a seminar, there they explained it in detail, that you start in arbitration, which is the proper under the Arbitration Act, and the arbitrator is there, plus a mediator is also sitting there. So you start the procedure of arbitration and then you settle it with mediation, so you save time about cross-examination, evidence, etc., which was a very good thing. And I hope that the legislatures and the policy makers are hearing us and they think about it, because this is going to solve a lot of problem, pendency of litigation also. Third thing which was said by in the previous panelists when they were discussing about mediation and conciliation and arbitration, whether it is just a tag or we are actually entering into it in India. So what I feel is, whenever in India, what I have seen in my personal experience, all the clients that are the multinationals, they are moving away from India. They don't want to do any matter in India for arbitration. For example, Vodafone has gone out of the country. It was not in this country. The arbitration was not done here. So why are they doing it? We have to do the proper analysis of what is lacking, why India is not a hub. India is not even ready for that. In the previous session, Mr. Sudhir Sharma said about the infrastructure, the logistic, the stenographer, assistance. Here in India, you need to have, stenographers, you need to have interpreters who are par excellence. So we need to have first the workforce ready with us. Once they are ready, then we have to have our lawyers to be ready for that. And I want to emphasize on one thing, that now the youth is there, the young lawyers are there, and I feel in our college curriculum, in the law faculties, different law faculties or national law schools, arbitration should be taught as a basic subject from the beginning. So we can start changing the mindset of our talent pool who are sitting here also and in the audience, because they are the one who are going to take, in another 10 years, I think the legal system in our country is going to change, because I've heard that the policy makers are seriously thinking about mediation and arbitration to be the basic process and leave the old age litigation system.
So that is what I feel that our younger generation should be taught for arbitration. For example, I keep thinking about the innovative things that we can also have, like we have the Judicial Services Academy. We should have some academy for arbitration also, where basic arbitration laws can be taught and it can be taken further. I was going through the Canadian Arbitration Center's preamble. That preamble itself is so enriching. If I will just read it for everybody. Here is a strong desire among those who have disputes to control the time and cost of binding dispute resolution process. To create an efficient and cost-effective arbitration process, these rules, among other things, restrict the length of material that may be presented and the time to present evidence and argument. The arbitrator will be expected to manage the proceeding actively and aggressively to ensure adherence to these rules. By agreeing to the process under these rules, the parties acknowledge the restriction and agree that the rules will give them a fair and reasonable opportunity to present their case and respond to the case presented by other party. So it is so clear. So the understanding, if the understanding is clear from the beginning, there will be no problem. So I think personally that we need lots of homework to be done before inviting international arbitration in our countries. Though we are strong enough, our next generation is ready for that, and we can certainly do that. Thank you.
You'll take it now. Okay. So, thank you again, everyone, for arranging this conference, Moses, colleagues, and for inviting me now to sit in the spotlight. It's quite exciting to sit here beneath these array of lights. Yesterday morning, the Chief Justice started his comments reflecting on the courage that international arbitration practitioners project when they engage in case management, taking cases without regard to political changes in the world and allegiances, and representing their clients to the best of their ability in the face of sometimes quite difficult situations. For a moment, as he was speaking, I felt quite brave myself, and I felt quite courageous. And I hope that reflects in the way I represent my clients when I do, although I doubt very much that I've had an opportunity to face political adversity. The question really is, in the face of where Asia now stands in arbitration, is how advocates and advisors in places like India, where the world of arbitration is still in development, what courage can you show, or we show our clients, when we advise them on how to conduct arbitration? How do we take that message of courage and turn it into a force for good towards the development of arbitration, particularly here in India, I would say? Do we take it as far as burning down the village, suggested by Rohini this morning, in order so that we can build a new village? I am not sure it's necessary to go that far. But my conclusions, after hearing a lot of discussion in the past 2 days about the state of play in India and the desired state of play in India, is that the courage that is required now focuses on two main areas. One, the judiciary needs to be a little bit more brave in coming out forcefully in support of arbitration. And the first steps have already been made with cases in the past few years, stepping back from control of arbitrations, nearly at least, if not completely, abolishing this idea that you could appeal an arbitration on grounds of public policy, an arbitration award on grounds of public policy. It's a very good development. The second place really is in the appointment of arbitrators. And here again, I think it's incumbent on us advisors to tell our clients and to persuade our clients that the right choice of arbitrator isn't always the most senior judge in the room who is available. And I think this is the most critical point where advisors can play a role and need to play a role and can even help their clients in doing so. The suggestion that you benefit your client by having a judge who has been practicing litigation for his entire life or her entire life and might find it difficult to understand new concepts, develop new procedures, become more adept at understanding the parties before him rather than the procedures that he has always practiced is, I think, false. I think people have talked about training lawyers to become arbitrators. I'm not sure there is a formal training that can prepare people, but I think choosing people who have learned the topic academically or through practice, who have not necessarily been through the judicial stream, is probably the best way to go. I think choosing young arbitrators, and I sadly no longer class myself in that class, so I'm not advertising my own skills, but choosing young arbitrators benefits parties in ways that are really not properly understood by parties or counsel. Choosing an arbitrator who is relatively newcomer promises your client not that they will get a more favorable hearing, but promises your client that there will be at least one energetic member of the panel who will take the case forward, who will be engaged fully, who has still got something to prove and a reputation to build, and so can help the entire process to move forward in a more successful and succinct manner. You might even be able to stick with the 18-month maximum, which is now required under the law. As to engaging Asia more widely, as I tried to reflect in my comments yesterday morning, through my own practice over the past 20 years, I have seen Asia, and India in particular, move from a place of little engagement to now, today, a place of complete, full engagement, both in terms of the counsel we see against us when we represent parties in arbitrations with an Asian components, certainly in terms of the clients, whose sophistication and understanding of business and the arbitral procedures is second to none. And gradually, through dedicated centers in particularly Singapore and Hong Kong at the moment, we see an understanding of how the process should evolve and be conducted properly. And I think this understanding is now also available in India. And whilst it will take some time, there is absolutely no question in my mind that India will become a center for international arbitration, subject to the caveat that you mentioned, Nicholas, which I also reflected on yesterday, whether Indian parties will be able always to persuade their counterparties to agree to arbitration seated in India, because foreign parties will be reluctant to. And in that regard, I don't think that foreign parties will be expressing a view on India. If you look at the statistics of LCIA arbitration, there are some English parties who engage in LCIA arbitration, but the vast majority of cases involve parties from two different jurisdictions, non-English parties. And that's because they chose London and England for its neutrality. Which brings me to a final point. London, England, should it be Mumbai, India, or Delhi, India? When we were asked this controversial question earlier in the day, I felt like picking up both hands. And I was thinking in particular of Switzerland, one of the I suppose, traditional and oldest centers for international arbitration. We have Geneva, we have Zurich. They are both thriving centers for international arbitration. And in a country the size of India, which could swallow a number of Switzerlands, and if not the entire continent or entire Western Europe within its borders, I think you could safely have at least 2 cities where you can have arbitral centers. So there is no concern there either. Abi.
Hi. I think in most of arbitration conferences and the trend that generally has been in this conference also, that a few issues always come up and the view is largely unanimous on those few issues. I actually have a completely opposite view to certain views which I usually hear in various international arbitration conferences and which I have heard in this conference. I think one such view really that comes up in every Indian conference is that why in India we always appoint a retired judge of a high court or a Supreme Court as an arbitrator. And why don't we create an arbitration bar and create specialist arbitrators who can be appointed as arbitrators? My position and my thinking is that we should actually appoint retired judges, and I feel that we should appoint retired judges is because in India we have a very, very good pool of retired judges who've spent a large amount of their career in deciding and adjudicating civil disputes. So this whole retired judge bashing that we do is losing sight of the fact that we do actually have a big pool. And let me tell you, I'm not related to any judge, and I have no aspirations to become a judge. So it's not that I'm saying that this just because of that, but I think we have a very, very good pool of very highly qualified judges, especially our Supreme Court judges who are retired from Supreme Court. They're not even allowed to practice in any court in our country under our constitution. So rather than making them just sit at home, when they are at the age of 65, they can still move around and they can still decide disputes. I think the policy should be to have a training system, as Nandini said, and use this talent pool that we have among retired judges and promote them as arbitrators. So I think rather than taking the fixed position that no, in India, why you always appoint a retired judge? If you go to London, you'll see that they'll appoint, a top QC from some set. Why don't we do here? Why should we do here? We have a really, really good pool of good retired judges who've looked at disputes from all sides of the angle. They've held writ courts, they've held civil disputes, they've held criminal disputes, so they have a whole holistic understanding of the system. I think to get them ready for an arbitration so that they understand that the procedures can be a bit more relaxed in an arbitration, you give them the right training, have a training system, and use them. So I think that's my thought on using retired judges. On the whole idea that in India we need to ensure that courts don't interfere with arbitral awards. Before the new act came in, I used to think that courts interfere a lot with arbitral awards. But one has to actually see these arbitral awards before blaming the courts in interfering with these arbitral awards. And once I asked a sitting high court judge that after the new act, will you interfere? And he said, yes, I will if I feel that an award is dishonest. So, the problem with our country is that we also have some very bizarre awards given by arbitrators. And then you don't expect the courts to just sit around and allow people's rights to be quadrupled just because, and walked over, simply because the act is very restrictive and says that you have to find some very high threshold of public policy argument to interfere. If an award is dishonest, if an award on the face looks that, there's something wrong in it, a construction of a contract which would have simply meant X, you're doing all kinds of things to construe it as Y, then why should we restrain our courts from not interfering in such an award? And why should we allow such an award to be upheld by a process of law? Because, at the end of the day, the principle is that justice should be done, regardless of whether it is arbitration or whether it is a suit in a court of law. So according to me, I think courts should continue to interfere, and they should vigorously interfere where they see that there has been some injustice done, where they see that there is some kind of a dishonesty or there's something really wrong with an arbitration award, even if it comes to construction of a contract. And I think Indian courts will continue to do that. Third is arbitration in India. Now, we want to make this perfect system of arbitration in India, which is world class and which is what we have in European countries or what we have in London. But, we need to understand that arbitration in itself cannot survive if we don't rehaul our entire general civil litigation system. So if our civil justice system is going to be a pre-Wolf, what English lawyers would understand, pre-Wolf reform system, which comes from the British in the 18th century, then you can't expect that arbitration can be made so good that it works as a standalone system. No, arbitration works with the entire civil justice system. And till we change our civil justice system, till we change our CPC, which will then change the mindset in the way we approach civil litigation, then only we can make an impact with an arbitration. It's like, it's like saying that make India the best place for arbitration is like saying, get me the Lamborghini or the Ferrari car on a road which is not built. So I think we are far away from creating that system, and I think we need to rehaul our entire civil litigation system before we can think of a world-class arbitration system. That leads me to the argument of certainty and uncertainty. The argument that was made in the panel before here was, why don't we define what is public policy and have certain baskets? This is public policy, this is not public policy. And I have mixed feelings about it. I feel that no, we can't do that. We can't do that because today in a case, as it was highlighted by the previous panel, whether FEMA is a public policy, is it a public policy? Is it a ground for an interference by court? A particular court has said no, it is not. And a particular court may say it is. But it's not FEMA, it's what were the facts and circumstances? I mean, did parties knew that this was a prohibited area of investment in India and still went ahead and invested? If they did, then they will suffer the consequences. But if parties were not aware, or there was some ambiguity in the law and parties went and did the transaction, and then one party is particularly using some technical point in FEMA to stop enforcement of an award, then of course it's an issue. It's not an issue of public policy. So we can't have a straight jacket kind of a formula as to what is public policy, what is not public policy. We in India live in a very uncertain world. I mean, I don't know if I can consume alcohol tomorrow in this hotel or not, because someone might say the road outside is a highway, and it's not safe for all of us. So we live in a largely uncertain world, and I think that's also the fun of it. And that's also the fun of it. So we never know what is the right answer and what is the wrong answer. So when we don't know what is the right answer, wrong answer, we can't expect arbitration to always give us the right answer or the wrong answer. So these are my few thoughts about arbitration in India generally.
I think after hearing all the panelists were here and was getting a feedback, since I wasn't here yesterday, of what was discussed starting from the Honorable Chief Justice. And what I feel, I think the criticism or the remarks all reach to one point and one goal, which is quality. I think what we are expecting is that any justice delivery system must deliver in a position of quality, so that the future hurdles, like Abhimanyu points out, a bizarre award, or to start with whether the procedure was followed saving time and cost, or whether, as Sai said, the correct appointment of an arbitrator, all of which leads up to what is the quality of the dispute resolution process that you want to achieve. As far as our country is concerned also, which is one of the largest economies in Asia, but we turn out and say we do not have an adequate set of infrastructure. And we then go down to a smallest minuscule thing to say that we don't have transcriptors in India, and that's why we want to go to Singapore to do our arbitration. These all lead to a position which one would say a system which we do not want to accept or build. In my view, the system is available, and I beg to differ with Abhimanyu to say that, if there is a retirement age in this country, we must honor it. One must learn to go home. And the delivery system, if a man is not fit to sit as a Supreme Court judge, you are then bringing him down to sit down and do your arbitration, and then take that award to even a district court in this country under challenge. I don't know what is the system that you are resurrecting or which quality zone that you are going into. So somewhere I think this entire system needs to undergo an overhaul change to understand that what is the objective of the alternate dispute resolution mechanism, a holistic approach. And I personally feel that it needs a very holistic understanding of what a party or a stakeholder needs out of the process that he has chosen, which is arbitration. That holistic approach is completely missing from the full assessment. One of the key things, I think, even in the existing system, if adopted, missing the transcriptor, missing a good stenographer, missing a good plush position where I will go and arbitrate and accept your Niti Bagh club in New Delhi or a Woodhouse Gymkhana in Mumbai. I think what is needed for the current system to adopt is a project management system. An arbitrator needs to understand how he needs to conduct his proceedings. He is not bound by a fixed procedure. And if he adopts a project management system which is missing as a discipline, I think you are going to be able to deliver a good quality solution to an alternative dispute resolution mechanism. Enough discussion happens at several conferences that I attend also, where people talk of saving time and costs. The legislature now amended in this country also seems to try and achieve saving time and costs. I think it's an unreasonable position to pitch these two words, because if you want to save time and costs, you are losing quality. I do not agree with the position of the 12-month. I heard even in the previous session, and I was quite vociferous even at the Niti Aayog conference, to say that 12-month position is unrealistic even globally. And what we call for then is judicial intervention. As a practitioner, I know appointment of arbitrators in various high courts are presently, and statistically I did even try and read up last night, Rajasthan High Court has appointment of arbitrators pending for 6 years now. Section 11 positions have not moved in several courts. So if we do not avoid judicial interference, I think that 12-month period after which I want to go and apply for my 6 months, I don't know when I'll get heard for the 6 months extension. What is the realistic position that the saving time and cost needs to achieve? Self-discipline is missing, and therefore if the arbitrator starts with a nice project management plan with the parties, I think that self-discipline to achieve time and cost can automatically be achieved. There was a change in the 2010 UNCITRAL model law also, which used the phrase earlier, fully heard, and then it's now changed to reasonably heard. So I think the parties and the lawyers must understand that if we are reasonably heard and if you are reasonably able to assuage your client's cause, you've achieved your purpose. You can't go on and on. And if that project management timeline is adhered by the arbitrator himself as the leader, I think all the goals and hurdles that we are facing, the infrastructural criticism that we keep coming up with as far as India is concerned, we'll be able to achieve a good solution for an alternative dispute resolution mechanism. Thank you.
Any of the panelists like to respond?
Two things. First, what Abhimanyu said, that we should use the talent of the retired judges and we should not do judge bashing. We are not doing any judge bashing here at all. But what I feel is, irrespective of the judges, there are other people also who are, expertise in their field. So first of all in India, when we have an arbitration, first of all we start keeping like you said about the project management for a particular arbitration. So the project management is this, that we first check who's free, whose diary is free. Because if we have 3 arbitrators, one is the chief arbitrator, presiding arbitrator. So one will say, no, I'm not here, I'm in London, I'm here, different places. So, we are not doing judge bashing at all, because we run after them. We run after them and we make them so special. There are other people also, there are other experts, there are other Supreme Court advocates who are good. In fact, in the High Court also, so we have to look for potential in people and accordingly choose our arbitrators. See, in India what happens that we don't have a panel of arbitrators from which we can pick, because first of all we will not agree, then our clients will not agree, they go after names, they run after names. So that is where the substance is lacking, I feel. And I feel that, we should appoint arbitrators from all fields, like it was said by Mr. Behel, that, chartered accountants can be taken. For example, now the infrastructure law is coming, so we need someone who is a specialist in infrastructure field.
So I personally feel that along with the panel of arbitrators, or we can keep a separate person who is a specialist, but certainly not only judges, we should endeavor to do and explore our limits and appoint arbitrators not only from the pool of retired judges, but from everywhere. That's my take.
Can I just say on that, I think it all comes down, what you said, it's all a matter of quality. What you need is highly qualified arbitrators. The discussion of whether or not these should be retired judges is not, it's not the first jurisdiction where this is discussed, right? It has the same discussion is happening in other jurisdictions. And the concern is, of course, what was said yesterday, is that retired judges tend to lead proceedings in the way they're used to lead court proceedings. And that is exactly what we don't want. Because arbitration will then lose one of its biggest advantages, which is the flexibility of arbitral proceedings, where the parties are the masters of the proceedings and not the judge. That said, it doesn't mean that all retired judges would do that. There are very, very good retired judges that adapt to this new role of being an arbitrator. And it brings me back to the equality argument. If you find highly qualified retired judges that are good arbitrators and not judges, then of course there's no reason not to appoint these people. So it really comes back to the quality argument, I think.
I missed addressing one point which our revered senior Mr. Khurshid raised at the previous panel in asking a very pertinent question as to is there a shift or a change with the new Commercial Courts Act? And I think as a practitioner, sir, my simple answer is that we've served the same old wine in a new decanter. The old wine is a good drink to have, but it's a new decanter and it doesn't change or it doesn't have any shift. You're having the same judges cloned into a commercial court judge who is applying the same principles, same theory. And let me just tell you, recently I've heard that the Mumbai High Court has now completely even turned down to interfere in execution matters to say commercial court. After an award is passed, when it gets into an execution mode, any order passed is not a decision and therefore we will not interfere. So with even this new law, the basic question of jurisdictions of these courts are now being raised. And I don't know when these controversies in our country will be put to rest. And therefore these courts will never really become effective. So unless there's a separate commercial court established with a clear demarcated position that this is your role, this is your job, this is the disputes and everything arising therefrom, without any controversy onto the word, what the word decision means, it will never change. We are back to the same system.
Questions? Any questions? Any comments from the floor?
Would anybody like to have the last word?
It's lunch.
If that's not the case, lunch shall have the last word. And I hand over back to the organizers.
Yeah, so we've come to the end of this two-day summit, very enriching, full of insights. So thank you, ladies and gentlemen, for gracing the occasion, for giving your inputs, for being such a patient audience. We thank Mr. Senior Advocate, Mr. Salman Khurshid, former Minister for Law and Justice, for being with us over the entire 2 days and supporting us. Thank you, sir. We thank all the dignitaries who graced the occasion yesterday and today. We are grateful for the presence of our Honorable Chief Justice of India. We also had the fortune of hosting the Secretary West in the Ministry of External Affairs, Ms. Ruchi Ghansham, yesterday. We had Her Highness Sheikha Haya Al Khalifa of Bahrain with us for both the days. So we thank her. We thank all the participants. We thank all the panelists, all the speakers, the moderators for being here. We thank all our sponsors, our media partners. Thank you, everyone. And we'll now proceed for lunch. Thank you.